Good afternoon, all. More than 5.5 hours of argument time has been requested, and I don't think you folks want to be around here that long. I would ask that you ask for the time that you need to convince us of your most important points. Remember that we're a hot bench, so you don't have to educate us about your appeal, but really try to convince us as to why your side should prevail. People versus James Benbow. Submitted. Rivas versus Restaurant Associates.
8 for appellant and 2 for
6, 2, and 5. City Mortgage versus Pantoja. How much time do you want, sir?
I'll take the 15 minutes.
I guess you weren't listening to what I was saying. I'll give you 5 and 2, and you, sir, I'll give you 5.
Oh, 5 and 2, yes.
Okay? Okay, have a seat. People versus David Scott.
Appellant request 6 and 2, Your Honor. Respondent request 7.
5, 2, and 5. People of the State of New York versus the National Rifle Association.
Appellant request 5 and 2.
Respondent request 5.
5, 2, and 5. Did I skip one? Oh, I apologize. I skipped one. Mora versus Branker. 5, 2, and 4. People versus Holt is submitted. To Wheel versus Sutton.
Your Honor, appellant 6 and 2, please. Respondent 3, Your Honor.
6, 2, and 3. Rodriguez versus Miller. I note there's a cross appeal here.
Good afternoon, Your Honor. The appellant request 5 and 2, please. Respondent, 4 minutes, please.
5, 2. No time on the cross. Are you going to? There's a cross appeal.
1 minute on the cross.
So 5, 2, you want 4, and then I'll give you a minute on the cross. Chazen versus Ma.
Appellant's request 5 and 2, Your Honor. Respondent's request 5.
Very well, 5, 2, and 5. Sylvan Hospitality versus St. Giles.
Appellant request 5 and 2. 5 minutes, please, for respondent.
5, 2, and 5. DB 232 Siegel Mez versus Moskowitz et al.
Respondent 5.
5, 2, and 5. People versus Ramon Herrera. 6, 2, and 6. Eteen versus MTA is submitted. Yang versus Knights Genesis is submitted. First case up is Rivas versus Restaurant Associates.
Good afternoon, Your Honors. The decision of the court below, we respectfully submit, should be reversed because plaintiff was an employee, was about 40 years of age, of the defendant, a large restaurant chain, and the situation was, to put it forward chronologically, on a Friday, midday, he went into the office to await the arrival of a semi-executive, a bookkeeper, for him to get reimbursed for some of his disbursements. And while there, he was speaking to 2 employees. They were both college young ladies, approximately 19, 20 years of age. They were the daughters of one of the senior executives of the defendant. And he had a polite, courteous, small talk, social exchange between himself and them. And during that conversation, they were talking about a Jeep, something that was of interest to the plaintiff, and they also had a conversation with regard to him admiring their educational efforts, and he spoke about when he was a teenager, he did not fulfill what he should have done in his education, and there was this exchange of fairly, what can only be described as small talk social exchange. That was Friday, June 16th. And at that meeting, one of the daughters, upon request of the plaintiff, gave her phone number.
Counsel, let me just ask you, all of those facts which we read about aren't that germane, because your case here is just for defamation
Yes, because,
of what happened on Monday. So,
yes, I'll get to Monday very quickly.
yeah, because that's really what this
Very
case
little
is.
happened on Saturday, except the plaintiff
We know.
texted to the one of the two
But does
daughters.
that matter, any of that matter, actually? In terms of getting the phone numbers, the texting, does
Well,
that
to
matter?
the father it did when he came in on Monday morning, he called what was in effect an emergency meeting. The plaintiff was a chef, to this meeting that was only scheduled Monday morning by the father, a senior executive at the defendant, and he called in 3 chefs who knew nothing about the one text of Saturday regarding, I'd be interested in going on a ride in your Jeep. And the father was apparently told that on Saturday. At this meeting, the father called the plaintiff a pedophile. He called him a child molester. And intertwined therewith, in the same breath, he was a pervert.
So within the context of the meeting, this is a very upset father, for whatever reasons, which are really not relevant to us. Would a reasonable person believe that the father's statements was an expression or a statement of opinion?
Well, it could be argued it was a mixed factual assertion and mixed opinion, because at the deposition, and I don't have enough time to go into all of the things the father said at the deposition, but he said to him these were sexual advances, and that when a 40-year-old guy talks to a young lady of approximately that age, then there's only it could only be one thing, a sexual advance. And as you did say, the father was rather excited about this, but that didn't give him the appropriate permission under the relevant law to call this client a decent, hardworking man who was fired on the spot, berated, defamed, insulted in a meeting that was not a meeting, but a punishment and scolding session, told him he's fired, contrary to company rules, which later, a week, was
You don't have a claim for wrongful termination. Your claim, isn't it just for the defamation?
yes.
So were all of these words, did they have a precise meaning that could be proven true or false? Were they
Yes.
subjective? I mean,
Yes.
pervert, isn't that just
Well, now we get to the court below. The court below said, well, pedophile, that's criminality. Plaintiff has a point. With regard to child molester, well, that's criminality. Plaintiff has a point. But pervert, that's a beauty in the eyes of the beholder, to quote the court below, or a case that the court cited. It could be something like this or something like that, and it's mixed. But in the same breath, to call someone a pedophile. and
But
a
isn't
pervert-
that hyperbole? I mean, what's going on? You have an outraged father because apparently your client, the father perceived, was making advance on a young woman. Isn't it just outrage and hyperbole that the father is expressing?
That's like, how far do we allow outrage to go? Here's an innocent kitchen worker who had no criminal record, who never, ever thought in terms of pedophilia or child molestation, and was called this in front of 3 chefs, who, by the way,
If I may, I would like to go back, because I said I like to go back. You've talked about mixed opinion. So let's talk about that, because it seems to be some type of, let's say, disciplinary meeting, and all of the people involved, they were really the superiors to the plaintiff. He reported to all of them. And so when you're saying, mixed opinion, isn't it true that everyone knew about the plaintiff's interactions with the daughters? They certainly knew about the substance of the text messages. So what facts allegedly were not disclosed? Everybody knew what was going on?
No, Your Honor. These three chefs who were the contemporaries and the co-chefs of the plaintiff, they didn't know what happened Saturday. They found out about what happened Saturday at this, quote, meeting. It was not a meeting. It was a room that the plaintiff was brought into where he was berated, insulted, and defamed and told to take his uniform off and not come back. However, Human Resources a week later said he did nothing wrong. The girls gave him their number.
But, sir, that's not the issue. But in any event, your time's
I
up.
was asking the judge's question.
Okay, your time is
You
up.
answered it. Thank you.
The three chefs were brought in unnecessarily, so there was an audience, so that when the father of the two college employees, summer employees, were not to say exonerated, but the father said, "I felt as if my daughters were unprotected," or something to that effect. Mr. McLaughlin wanted an audience for this defamatory. These three chefs were unnecessary. There was another executive there. It could be argued, well, maybe she should have been there. Even she didn't have to be there.
Please have a seat. Your time is up. You'll get a couple more minutes in reply. Go ahead, counsel.
Good afternoon, Your Honors. May it please the court, Sean Clark of Littler Mendelsohn on behalf of the respondents.
So your adversary concedes maybe some opinion, but his position is that it's mixed fact and opinion. What's your response to that?
That's wrong. A mixed fact and opinion requires that the speaker implies some basis of knowledge that's not being disclosed to the listener. That was not the case here. The record reflects that that Mr. McLaughlin called the meeting. At the start of the meeting, he went through the facts underlying the termination decision, including this inappropriate interaction that Mr. Rivas had with the daughters and the text message, and then he made the statements that Mr. Rivas is alleging are defamatory. So it would have been clear to everybody hearing that the basis of those opinions were the facts that were just outlined in the meeting a few minutes earlier.
Well, does pedophile have a meaning that can be proven objectively true or false?
I don't think so, but that's not the only standard here. So even assuming pedophile could be proved true or false, the standard requires us to look at context. And the context here was we had an upset father bothered by an interaction between his 42-year-old subordinate and two daughters.
But so does a father's justifiable anger at an adult male's comments directed at that person's daughter give license to make, let's face it, pretty loaded charges? That's a very serious thing to call someone or suggest that someone is, whether it be a child molester or a pedophile.
It may not give license. It doesn't make them defamatory. I think that this court's used the context of where it would be expected for someone to use fiery rhetoric. It would be expected here with an upset father to use fiery rhetoric.
Well, the plaintiff himself stated that Mr. McLaughlin's eyes were bulging, that he was clearly extremely angry at this time.
Which supports the position that these were opinions, not facts. The context of the communication from Mr. McLaughlin to the appellant was anger. And appellant himself acknowledged in his deposition that he thought Mr. McLaughlin was being hyperbolic and exaggerating. So he knew Mr. McLaughlin was upset. He knew that Mr. McLaughlin was being a bit over the top, but in an opinion, not in a defamatory fact. Appellant makes the argument that the three chefs who attended the meeting were brought as some witnesses and weren't proper there. The record's pretty clear. These were executive chefs. I'll actually cite to page 91 of the record. It's plaintiff's own deposition testimony. They were his bosses. They were there because everybody at the meeting had an interest in knowing the reasons for the termination of this plaintiff. Whether they be right or wrong, the reasons were not defamatory. One final point. The court didn't reach the issue of a qualified common interest privilege, but it did observe that the statements were made at this disciplinary meeting, that they were made in front of managers, all of whom were familiar with the facts. So appellant said that these chefs didn't know what had happened until Saturday. That's not in the record. That's nowhere in the record. So the court could, even if it finds that these statements were statements of fact, affirm on the basis that these statements were made under a qualified common interest privilege to individuals who had a common interest in knowing the outcome of this meeting. So unless the court has other questions, I'll yield back the rest of my time.
Thank you, counsel.
Under the theory of the defense, who said, and I was a little astonished, he said, well, maybe he went a bit over the top. A bit over the top? This was a man. This was a working man. A man who had no criminal record. A man who was a good worker, had worked there for 5 years.
But I think the question we asked you was, context matters, doesn't it? And the context of this disciplinary action, I'm not condoning what the defendant said, but was he was upset, he was about to terminate, executive chefs were there. Within the context of that meeting, weren't those statements just mere?
There is no case in America that says, well, if you're upset, you can say anything you want.
No, but it's a meeting. It's a meeting being held with other executives of the company to decide what to do with this individual. Doesn't that context matter?
That meeting was held a week later when they exonerated the plaintiff. This was not a meeting where plaintiff had a full and fair hearing and was found to have done something wrong by social talk and phone number exchanges with daughters. He was not found guilty of something at a hearing. He was found guilty of something on Saturday and brought in on Monday to be told what the father thought of him. And yes, the father was a bit over the top, very excited. Hyperbole, that word can mean many things, but under the theory of the court below, someone could be defamed 9 times in a conversation and then said, and what's more, you're a pervert. Because the court below said plaintiff had a point, being called a pedophile and being called a child molester, but this was a little difficult to deal with the word pervert. That's go either way. So defame someone 9 times and then say, and what's more, you're a pervert.
Sir,
There's
how old were the two young ladies?
I believe 19 to 20. They were both over 18. I think one was 20, one was 19, or I may have the number wrong, but they were not under 18. They were both college students over the age of 18.
Doesn't that sort of cut against a finding that was a factual statement, that these young women were not children in a technical sense, weren't subject to a pedophile or a child molester?
Well, the father probably viewed them as children. They were his children, and maybe they were over 18, and maybe they were capable of joining the army and getting killed or voting. But to the father, they were his child. That's understandable. I'm a grandfather. I understand what that means. Doesn't give me a license to go over to my grandson's neighbor, wherever it is, and call him something because my grandson threw something. I could say, he littered your lawn, but I can't call that man something that I would, if I was over the top. I can't just say anything I want. They defamed an innocent worker, and as the justice said, we're not suing for his lost wages. They know he found another job. I'm not trying to minimize his damages. This scarred him for the rest of his life. Man had a perfect record.
Thank you, sir. Your time's up. It's a red light.
Thank you.
City Mortgage versus Pantoja.
Good afternoon, Your Honors. May I proceed?
You may.
This action on appeal was brought to foreclose an ABN mortgage. In the seminal case of ABN versus Pantoja, this court found that the grantor's ABN mortgage had priority over the purchaser's mortgage and deed because it was recorded earlier than both. And that decision,
So this action has
Yes.
been discontinued, correct?
yes, it has been
If it's
discontinued.
been discontinued, do we even have jurisdiction to hear this appeal? There's no action pending before us, so how can we hear this appeal?
Well, that is a good point, Your Honor, but this appeal was brought to foreclose an ABN AMRO mortgage.
Wouldn't you have to
So
vacate,
therefore-
wouldn't you have to vacate the discontinuance and then make your motions, et cetera, before you proceed?
I would ordinarily, Your Honor, and I did appreciate that argument by the City Mortgage in their brief, but I think there's a mistaken focus on this appeal on the part of the parties. I'm on appeal, but not basically because I want to recover under a counterclaim or some sort of a pleading that I have to vacate the discontinuance order to make or to move. My appeal is based on the judgment that was docketed in this case, which is the equivalent of the Supreme Court order. And that's what I'm seeking to enforce. My procedural research hasn't, with certitude, given me the right to argue that I could enforce the judgment, or I could enforce or execute the judgment in a foreclosure action that's been discontinued. But that's the effort I'm trying to make. I'm starting from the judgment, and I'm interpreting the judgment and its effect on the foreclosure action, namely the satisfaction of the ABN mortgage. The ABN mortgage recorded with a grant of freehold interest in the subject property, which conveyance accompanied with a warranty of title had priority over the Collado purchaser's mortgage and deed because it was recorded earlier than both. I cited this court's holding in the ABN case as authority for the principle by which I am presenting this appeal. I also respectfully refer the court to New York Property, Section 253, that defines the construction of covenants and grants of freehold interest in real property. The ABN case consequently did bestow me possessory interests under the covenants used in the grants of the freehold interest, particularly two covenants, Your Honor, that must be construed under Real Property Law 235, 4 and 5, subdivision 4 and 5, and further supports the motion, which is sequence number 5 for summary judgment, against City Mortgage for money damages. The ABN covenant that the grantor, which was the borrower, which is me, will execute, if I may, Your Honor, just quote this section of the law, and I understand this is a hot court, very familiar with the law, but it gave me mandatory language under the ABN mortgage that I had to give this grant to freehold interest.
Okay, why don't you reserve the
I want
rest
to get
for...
into a little of that, but I know my time is up on
Okay,
it.
but you have some time in reply.
Thank you.
Good afternoon, Your Honors. My name is Todd Marks. I'm here on behalf of the plaintiff respondent, City Mortgage. I won't take very much of your time. I just want to reiterate a couple of strong points of our case. The first is that The lower court had a correct holding in the fact that this action was voluntarily discontinued upon notice of motion, that notice of motion was served upon the defendant appellant. That was unopposed, the order entered, and the order was filed. The subsequent filings thereafter or long after the action was already discontinued, and so the lower court's holding was accurate in that there was no relief that could be obtained by those holdings.
What's your view, assuming, well, if we were to reach the merits, what's your view about the application?
I'm sorry?
Assuming we were to reach the merits, what is your view on the merits as to Mr. Pentoa's application?
As to his judgments, the judgments?
Yes.
Well, those weren't before the court, so the judgments that he was purported to enter were not a part of the action. This is simply a mortgage foreclosure action. So to the extent that he had these additional claims that weren't even before the court, so there was no, the merits couldn't even been reached. I mean, there was no cause of action filed. There was no claim against the court. I mean, the purported judgments that were submitted were pretty much apropos of nothing, and then to the extent of the foreclosure action, because the defendant appellant was served, he failed to respond with any defenses or counterclaims thereafter. There were, over the course of 20 years of litigating this case, there were a couple of attempts to vacate that default, or they were all unsuccessful. And to the extent that he filed an application to attempt to vacate his default, to attempt to assert counterclaims, it was approximately 15 years thereafter his default. That application was not accepted either because the voluntarily discontinuance occurred prior to that, and there was no opposition to that discontinuance. So whatever claims that may have been or may have been attempted to be arisen were subsequently abandoned, or subsequently, upon the discontinuance of the action, it was as if they were never filed. I mean, there was nothing to them. So if there was a separate cause of action to be filed thereafter, that might be one thing, but as to this matter before the court, the issue is not before the court, it's quite simply.
Thank you, sir.
Thank you, Your Honor.
Mr. Pentoa,
May I, Your Honor?
please.
Yes, the city mortgage argument is the one I think I addressed, and I hope it's a novel question, and I'm not wasting the court's time, and that is whether I can continue to pursue or enforce a judgment in a discontinued action, and I don't see it. And I don't see city mortgage giving me any real procedural bar with respect
Doesn't
to
the
that.
case law essentially not support your position? Doesn't case law hold that once the action is discontinued, we're divested of jurisdiction?
Yes, in normal cases, but none of the authority that I read cited by respondent city mortgage included a mortgage entered in the very action that was discontinued. And I think that's where the confusion might be for city mortgage, because even though they took over the case, it was an ABN AMRO mortgage, and that's when this court, in its decision and its wisdom, implicated 291 and gave that mortgage historically in this action a priority. And what's also in that mortgage is my grants, my freehold grants, which substantively proves the entire case. Why, after judgment, I'd have to recite it again in another action, or promotes security of actions or courts. In that sense, I thought, Your Honor, respectfully, appeal would be in a more appropriate way for me to enforce the city mortgage judgment. And if I could just have time to go over some of the covenants, which is the basis for my cause of action.
We'll review the case, and
Thank you, Your Honor.
thank you both. People versus David Scott. You may proceed, counsel.
Thank you. Good afternoon, and may it please the court. My name is Rosemary Herbert. I'm with the Office of the Appellate Defender, and I represent David Scott. Mr. Scott was detained at gunpoint by police officers who lacked reasonable suspicion that he was involved in any crime. Most significantly, Mr. Scott did not match the only specific element of an otherwise very general description of suspects in a robbery. Now, I think respondent agrees that the detention at issue here was at least a level 3 detention that requires reasonable suspicion, and the record supports that. Mr. Scott was confronted by officers at gunpoint who pushed him up against the wall and ordered him to freeze. So I think there's no question that this required reasonable suspicion, and that was lacking here.
How about under the totality of the circumstances? A robbery occurred nearby. The officer, based on prior experience, went to the building. He heard frantic, nervous voices. Defendant opened the door with an armful of property. Considering all that, does that change your opinion about that?
Absolutely not, Your Honor, for several reasons. First of all, the factors that Your Honor had cited, which were relied on by the court below, do not provide reasonable suspicion. They are certainly factors that would require or would reasonably require officers to conduct further investigation, but they do not authorize a gunpoint forcible detention at the point at which it happened. The factors that Your Honor cited, the proximity, the location was approximately, I think, 4 blocks from the scene of the robbery, but it's worth noting that the officers were informed that the suspects had fled east. The location that they stopped Mr. Scott at is north and slightly west of the location of the robbery. So this isn't where they didn't observe suspects fleeing into this building.
But isn't it just police work? I mean, a police hunch based on an experienced officer, training, I think, another officer, and based on his prior experience, knowing that folks go into the building close by.
Well, first of all, obviously, a hunch does not provide reasonable suspicion. And when Officer Ellison, who was the more experienced officer, was asked about this prior experience, he described a single incident in which suspects were observed fleeing into the building. And that is a very different situation. I think to assume when there's a robbery and suspects are people of color that they naturally were associated with a housing project reflects a certain level of racial bias, to say the very least.
But that's not the only element. There was the nervous
Absolutely.
voices, the fact that the defendant was holding property. I think wires were sticking out. And
Absolutely, Your Honor.
And
but
the fact of what the voices actually said, which was that they got out of there quick.
Your Honor, the officers described, both officers described how they heard, they entered the building, they heard conversation from above, they heard excited voices, and they heard just snippets of the conversation. They could not make out the speakers. They both said that they heard words to the effect of, we got out of there fast, something like that. Again, they did not know that the person that they were stopping at gunpoint was one of the people speaking. Those conversations are ambiguous, especially without any connection to the person they're detaining at gunpoint, and they certainly could have prompted further investigation, but that's not what the officers did. They immediately went to the level of a forcible detention. If I might...
Well, isn't the fact that the officers brandished their firearms explainable by the fact the radio call indicated it was a gunpoint robbery?
Your Honor, I understand why the officers unholstered their weapons, but again, they needed to take further action before they could detain a suspect. At the time that they stopped Mr. Scott at gunpoint, they did not know that they did not have reasonable suspicion to believe that he was involved in this gunpoint robbery.
My understanding was two of the officers were standing outside in the hallway, and they overheard these, what they stated were excited voices saying, as you indicated. And before they pushed open the door, the defendant opened the door from inside and kind of started to walk out into the hallway, not expecting the officers to be there, of course, carrying a lot of the items, a laptop and other electronics that they could see. He was holding those and also seemingly holding up his pants. So they saw a lot of these things. And that goes to Judge Singh's indication about a totality of the circumstances.
Well, absolutely. The totality of the circumstances is the relevant inquiry here. With respect to the property, first of all, any suggestion that he was holding up his pants, that came later. So that's not at the point where they're forcibly detaining him. And they observed property in his hands. It's a little unclear what they observed at the moment they were pushing in, but even assuming they saw something resembling a laptop, that is a common portable electronic device.
And what time of the morning was this?
This was early in the morning, but again, this is in an apartment building where you can expect that somebody might be taking a laptop from one location to another. And if I might very briefly say that on top of that, even if all of these circumstances provided reasonable suspicion, that reasonable suspicion was negated by the fact that Mr. Scott did not match the description. The description was black males, one red shirt, one black shirt. He had on a white shirt. So under those totality of the circumstances, the police did not have reasonable suspicion. And for those reasons, we'd ask that the conviction be reversed.
Thank you. You may proceed.
Good afternoon, Your Honor. Sylvia Wertheimer for the people.
Let me ask you, if I might, right away, to counsel's last point. I was concerned about that as I was reading the transcript and the hearing about the identification. Was it a red shirt and a black shirt, a red shirt and a white shirt, a red and a white shirt? It seemed that a lot of different calls came in with conflicting information. How do you deal with that?
I think that's right. I think the calls entail conflicting information, but I think what you had here, and I think it's correct that this victim misremembered the color of the shirt. But I think given all the other highly incriminating circumstances, the color of the shirt, the victim was looking at the face of somebody who was holding a gun to him and robbing him unexpectedly in the middle of the night. So he wouldn't necessarily have been focused on the color of the shirt.
He did say he was concentrating on the
face of the person. This is color of a T-shirt. A T-shirt is also an item of clothing that can be changed. That often is changed in an attempt to go away. So that certainly did not, that failure to match that description, that aspect of the description, did not negate the reasonable suspicion that resulted from the totality of the circumstances. As Your Honor,
What are the other circumstances you say support reasonable suspicion?
this is at 5:30 in the morning when few people, okay? This defendant opens the door after the police here go to a place that's within 4 blocks of a site report of a gunpoint robbery, close like within 15 or 20 minutes. They hear voices on the other side of the hallway saying, "We got out of there quickly," sounding very frantic. Defendant then opens the door, carrying an armful of property, including a laptop in a bag, which is precisely
But your
property.
adversary says, you know, people move laptops around. Their laptops are meant to be moved around.
Okay, not at 5:30 in the morning, right after saying, "We got out of there quickly." And again, it's reasonable suspicion. It's not proof beyond a reasonable doubt. The idea that these officers did not have the right to detain, I mean, that this was absolutely reasonable cause to believe that this defendant was involved in the gunpoint robbery that had just been reported at 15, 20 minutes earlier, 4 blocks away, of precisely the kind of property he was carrying.
Well, you're presumably in this area of Manhattan, there were a whole number of buildings in that area. How do you answer your friend's point that the only reason the officers chose to look in that particular building was because it was a housing project and the race of the individuals who were reported on the radio call?
Well, there was prior, I mean, it was close to the area of the reported robbery. There had been an earlier robbery where this police officer had seen somebody go into that building. And I mean, the police here circled the area at first. They didn't go directly here. They didn't see the robbers anyplace else. Then this was only 4 blocks away. Defendant says, oh, they fled east, but they fled east. The building was closest to 10th Avenue East. Then they went up a few blocks to 56th Street, and then the housing project was on 56 between 10th and 11th. There was nothing about the location that was inconsistent. It was close. It was close. It was good police work. And again, the fact that they those circumstances, they didn't. And there was more by the time they detained the defendant. They detained the defendant when there were all these other additional indicia of a reasonable suspicion. The idea that the defendant might just have been walking around for an unrelated reason at 5:30 in the morning with just the property that had just been stolen was something the police was not. It was at least reasonable for them to suspect the defendant had been involved.
And with respect to the stolen property, I believe it was Officer Ellison, right? Wasn't there some type of radio call or something displayed on the computer screen that indicated that the stolen property included the laptop that the defendant was holding as, you know, coming down the stairwell?
Absolutely. The radio communications on the screen, the testimony was that there was indication that the items stolen included a laptop. Now, defendant said in the reply brief there's no indication of a brand of laptop, but again, we're dealing with a reasonable suspicion, not proof beyond a reasonable doubt. So I think this was a case of clear reasonable suspicion. I see my time is up. I don't know if the court has questions about any of the other points that we did not address. If not, I'll rest on my brief and ask that the conviction be affirmed. Thank you.
Thank you, counsel.
Very briefly, Your Honors, I would direct the court to the case of People versus Thorne, which is analytically on all fours with this case. In that case, you have a pretty general description of a suspect. You have the police observe a suspect a few blocks north of the location of this incident, and he deviates from the description in a critical respect. The police say he's behaving suspiciously, he's trying to conceal his face. Again, in the court...
But totality, again, totality of circumstances included, as my colleague pointed out, a laptop that was on the radio call, right? So,
Well, the radio call was for a laptop. No description, no brand, nothing about it was
laptop's
a laptop.
a laptop. Yeah, it's a generic laptop. And here's a gentleman carrying a laptop at 5:30 in the morning, nervous voices, et cetera, right?
Again, I think that the information possessed by the police certainly gave them a basis to exercise their common law right to inquire, to say, perhaps, sir, where did you get that laptop? Is that your laptop? But not to force him up against a wall at gunpoint. Here, the police acted before acquiring the necessary level of suspicion. And again, in Thorne, the court was, emphasized the fact that the suspect in that case matched the description only in that he was a black male. And that's essentially what we have here. We have somebody who does not match the description, and with respect to the testimony was somewhat confused, but both officers ultimately landed on the fact that the description was for two black males, one red shirt, one black shirt. There's no indication that the radio run was description. It was their testimony that was confusing, not the radio run. And it's also worth noting in terms of the time of day, there were other people in the apartment building that the officers observed. So it was not like this was a desolate area, nor would you expect it to be. And with respect to there may have been good reason why the victim might have confused the description, but that doesn't affect the information in the possession of the police officers, which Mr. Scott did not match. Thank you, Your Honors.
Thank you, counsel. Thank you both. Mora versus Branker.
Good afternoon. May it please the court. My name is Christopher Grimaldi for the appellants. We are respectfully seeking that the decision of the court below be overturned. It's appellant's position that the court below erred in granting summary judgment in favor of the respondent because the court below failed to consider two material pieces of evidence. The first piece of evidence being the appellant operator's own testimony, and the second piece of evidence being the respondent's own admission against interest. The evidence, those two pieces of evidence, show that there are two different contradictory narratives as to how this accident occurred. Depending on which narrative is believed by a jury, and we would contend both reasonably could be believed, a jury could reasonably determine that appellant either bore no liability for this incident.
How's that? How's that? Your guy is the one who comes into the middle lane. He never sees the car there. What's the issue of fact with respect to whether or not there was a violation of 1148A of the VTO?
A violation what? Sorry, Your Honor.
1148 VTO.
48. Well, we would contend that our bus operator couldn't have seen respondent because respondent wasn't in the middle lane. The post-accident photographs.
Based on what? What's the testimony to suggest that the car driver wasn't in the middle lane?
Well, I mean, the most important piece of evidence to that fact is the car driver's own admission against interest, where he said he was changing lanes when the accident occurred. But even not considering that, the bus driver said that he was looking in his mirrors, he was slowly merging, he was allowing vehicles to pass, he had a clear view in his mirrors all the way to the beginning of the street, and yet he never saw the motorist in this
Are there
middle lane.
blind spots in vehicles that may have prevented him from seeing what was there to be seen, maybe?
I mean, absolutely there are.
So this is a bus, after all, right? So there must be quite a large blind spot.
Well, as is described in the papers, the bus mirrors have, I think it's 2 or 3 mirrors on the driver's side.
But nonetheless, the bus driver did not see plaintiff before the accident. He admitted that. He said he didn't know where the plaintiff came from. So it would just have been speculation that he was trying to merge because the plaintiff said he was going straight in the middle lane. It was stop and go traffic. And we understand why the bus went around. The bus went around because there was somebody parked in the bus lane, so we had to get around him. But he didn't see him, and the way the hit was, I don't see how you get away from that. I mean, he didn't see what was there to be seen.
Well, while it's accurate that the bus driver did concede that he didn't see the motorist before this accident, on summary judgment, the court's obliged to make all reasonable inferences in favor of the non-moving party, which here is the bus driver. And this bus driver...
What's the inference? What's the inference we should make with respect to the bus driver's testimony when he says he didn't see the car? I mean, there's no inference to be drawn.
Well, I mean, this to the point of the blind spot, the bus operator didn't look in his mirrors once and then make this turn or make this merge. He looked in his mirrors several times over the course.
And didn't see what was there to be seen.
Well, how can you see something that's not there? If you look in the middle lane...
Obviously, it was there because they ended up hitting each other, so they were there. I mean, the plaintiff was there. He didn't see him. And I think what we're both trying to ask is, I mean, how can you have an inference as to something that happened? Isn't what you're calling an inference, I'm calling speculation, because the plaintiff testified where he was and the defendant said he didn't see him. And where are you going to get any more testimony? The police officer that filled out the report didn't see anything. He just talked to people. And I'm not sure who he talked to anyway.
Well, our position would be the inference is based on the fact that the bus operator did look in the middle lane multiple times for a sufficient duration of time. If you look in the middle lane and you don't see the motorist there, it's reasonable to infer the reason that you don't see him is because he's not there. And when that's looked at, especially in corroboration with the motorist's own admission that he was merging lanes when the accident occurred.
But are the points of impact fatal to your position? This wasn't a side swipe, right? It was the back, the rear aspect, not flush with the rear, but the rear aspect of plaintiff's vehicle versus the front left aspect of the bus. So perhaps if they were both merging simultaneously, there'd be damage consistent with sort of a side swipe, but instead it's back aspect of plaintiff's vehicle and front driver's aspect of bus. So it's not as if what they're missing is the driver's missing is behind him or her. It's right parallel or in front of him or her.
Well, I'll be brief because I see my time has expired. I would say from the locations of the impact, we could exclude that this is a VTL 1129 case. I think there's no evidence that we were following behind.
It's 1148, right? I mean, that's really what it is.
Sorry, yeah. I think there's no evidence we were following behind the motorist before the accident occurred, but I think at minimum, even considering Your Honor's question, I guess your point, there would be an issue of comparative fault at minimum. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Michael Altman. I'm with the Altman Law Firm. We're appellate counsel for plaintiff respondent. Your Honors were correct that the defendant bus driver did not see anything. He was not able to raise an issue of fact. Counsel mentioned a statement a few times. I just want to point out that there were no quotation marks. This is not a direct quote. This is not a statement given by my client. Therefore, it was completely unadmissible. Justice Bluth got this completely correct. There's only one version of facts before
Why
the
is it
court.
not an admission?
Because we don't know what he said. It's just a summary. What we have is we have the transit supervisor's perception of what he said. If there were quotation marks around it, it might be a different case. But there weren't. It's his summary. It's not a direct quote, so it's not an admission.
Can otherwise inadmissible hearsay be used by a party opposing summary judgment to demonstrate the issue, the existence of an issue of fact?
Only if there were other evidence supporting that. You can't use only hearsay. If the court has no further questions, we'll rest. Thank you, Your Honors.
Counsel?
I would say the contention that the statement is inadmissible because it's just a summary, that was never raised before the court below.
Wasn't it a fact that the plaintiff testified that he never spoke to any of the defendant's representatives other than the defendant bus driver? So he's indicating that he never even spoke to the person that prepared their surprise, that he didn't give any kind of quote, that this is just a summary.
That is what he said, but that would go to an issue of fact as to the credibility of the statement. You know, the CPLR explicitly states that if it's within a business record, the business record is properly prepared according to regular business protocols, paraphrasing of course, then any other issues concerning the contents therein are issues of credibility for the jury to determine. And I would also just make note of the statement that the motorist gave to the appellant's investigator. The part where he alleges, the bus driver hit him on purpose is pretty consistent with his testimony, where he testified the bus driver got out of the vehicle and said, I hit you because you deserved it. I think it would be a pretty big coincidence for that sort of narrative to appear in both documents without, if one's completely fabricated. But either way, it's an issue for the jury to determine. Thank you, Your Honors.
Thank you. People of the State of New York versus the NRA. You may proceed, counsel.
Thank you, Your Honor. Good afternoon. This is Alessandra Lasuski representing defendant appellant. Defendant appellant seeks the reversal of the trial court's order grant a Rule 11 corporate representative deposition of the NYAJ in order to obtain factual non-privileged information clarifying the scope of the NYAJ's causes of action that are specifically vague and lacking specificity. Specifically, contention interrogatories answered by the NYAG lacked the necessary detail, including to provide the NRA a list of wrongful related party transactions, actions that the plaintiff contends are violations of the legally mandated protections for whistleblowers, and the supporting information for the NYAG's charge that the NRA failed to timely.
So the question, I guess, for me is, what's the role of the AG in this case? Is it acting merely as counsel? Or is it a party to the action? Because if it's a party to the action, then of course you're entitled to discovery as of right.
We argue that it's a party to the action.
Why isn't it acting just as counsel in this case? Because it turned over its investigative file, correct, to you, subject to any privilege logs. Wasn't it acting as counsel here? It is marshaling your evidence, your documents, and then giving you back the investigative file.
It's the only entity with the information about the claims that it's brought here. It conducted the investigations itself. It's the only entity that has the information underlying the claims it's brought here against the organization.
But you have the records, so why can't you, based on the records you have, determine what the theories, I guess, are, or the contentions are of the Attorney General?
We're still entitled to the full scope of discovery under CPLR 3.1.
I mean, then you'd be under your theory, you would be able to depose lawyers in every case to find out what information they know, separate and apart from what you already have in the record. Doesn't make any sense.
Not a private lawyer, Your Honor, just in this instance with the AG acting as a party here.
I mean, I just don't understand how the record that you have adduced during the discovery in this case, which I think is on trial at the very moment downtown.
Yes, that's correct.
Is, I mean, why you wouldn't have enough information and this would, deposing the attorney would not be the way to ask it. Couldn't you have asked focused interrogatories or something? If there's something-
Your Honor, I didn't mean to interrupt you. We did ask focus interrogatories, and the lower court actually did order amended responses to those contention interrogatories. Those were still rather insufficient to offer the NRA context as to what claims are actually being brought at trial. And I think it's fair to say that the NRA's rights are tied up into the full and fair discovery that's at issue here, to especially if this deposition was ordered rapidly, to be able to then put on its best defense when it orders its case in chief during the second half of the trial, starting January 29th.
You started your argument, and I think it's fully consistent with your brief, that you needed clarity as to the allegations or greater specifics as to allegations. Isn't that the function of a statement for a more definite pleading or of a demand for a bill of particulars than it is a deposition in the first instance?
That may be correct in the first instance, Your Honor. At this stage, after so many different discovery efforts that have been gone through with the state and insufficient responses on all fronts, this is seen as a quick way to get the necessary information to proceed in the case in chief. And we see the state as acting as a party here for purposes of Rule 11F of the Commercial Division, and to allow them to be immunized here from deposition would nullify 3102F and giving them a systematic...
Yet the other rule would be that if we were to agree with your position, then every time the AG brings a case, their attorneys would be subject to depositions as of right. And aren't there some concerns with respect to attorney-client privilege, work product, all those things then are square in the deposition?
Only, obviously, non-privileged or privileged information would not be subject to disclosure here. And obviously, were this deposition to take place, any attorney present from the AG side being disposed could properly object to any privileged inquiry on the record during that time. But this obviously would not apply to any instances in which the state is acting as counsel, but only as where the state is acting as a party.
What personal knowledge? Normally when you depose someone, they have personal knowledge.
Yes.
Last case, the folks were involved in an accident. What personal knowledge does the attorney have or the representative have to be able to answer those questions?
They have all the information that they know that is leading to the causes of action that they have here, and it's the first, 13th, and 15th cause of action that are unclear into specificity here. Thank you. I see my time is up, Your Honor.
Thank you, counsel.
Good afternoon, Matthew Grieco for the respondents. Trial court correctly declined to allow a deposition of plaintiff's counsel that was plainly an effort to obtain non-discoverable mental impressions and legal strategies, which I think my colleague on the other side's answer.
So what do we make of 3102F, which says states is properly a party, then discovery as with any private person? What should we make of that?
I read that rule simply to mean that the same rules apply to the state that apply to other people, which in this case, when the AG
that's what the NRA says.
But when the AG is acting as counsel, then the rule that applies is Liberty Petroleum. We're not saying that the Attorney General is subject to a special rule. We're saying that the same rule applies that applies to any other counsel, which is this court's controlling decision in Liberty Petroleum.
Was the Attorney General a nominal party in Liberty Petroleum?
It was not, but this court made clear that was the standard that applies to cases where a deposition is sought of counsel. And if you go back to this court's earlier decisions in Volkswagen and matter of Rothko, this court held in so many words that the Attorney General is not a party plaintiff when it acts in its protective enforcement capacity.
But didn't we distance ourselves from those decisions in People versus Katz?
No, the only thing that Katz has to say, and this part of Katz is actually only dicta because Katz actually reversed an order allowing deposition of the Attorney General. All Katz did was question the particular test that was described as the special circumstances test. It didn't distance itself at all from the principle that the Attorney General is not a party plaintiff. That part of Volkswagen and Matter of Rothko, and I mentioned Matter of Rothko because that is specifically in the charities context, and in fact, Article 8 of the EPTL, which is the exact article at issue here. That part remains good law to this day. It has been applied by many courts in this department and elsewhere long after Katz. So Katz did not alter that. And furthermore, I would point to the decision that Katz relied upon, which is a decision from the Court of Appeals called Best Line Products. And that decision makes it quite clear that where it's apparent, as it is here, that the principal purpose of a deposition is to get at the mental impressions of attorneys. And again, I think my colleague on the other side, her answer to the final question from the bench, made clear that that is what they're trying to get at here. They're looking for mental impressions and strategies about the complaint that was filed, that is not an appropriate...
But they would respond that they just want to understand your theories so they can better prepare a defense.
Well, on that, the standard of review here is abuse of discretion. So even if they could get past the Liberty Petroleum case, and as I'll get to, they can't, they would still be in the position that the special master and the trial court acted within their discretion in choosing contention interrogatories as the better approach to getting the information they need. I do not agree.
They respond that the responses were inadequate, which I'm sure you don't agree with. But what's the remedy there?
I think it gets back to what I was saying about the abuse of discretion, that I would point the court in particular to document 2432. That's 2432 on Supreme Court's docket. And that is a document where you can see the most recent version of the chart that was provided, and you can also see our cover letter rejecting their suggestion that the responses were inadequate. And the trial court and the special master, acting with their discretion, determined that answers to contention interrogatories were the better way to address this. And we make clear in that letter that I'm referencing in 2432 that we're and that was a letter to counsel that's in the record explaining that we were providing information beyond what we thought was necessary as a matter of avoiding litigation. So just to quickly walk through the Liberty Petroleum factors, the NRA has not identified any material and necessary information that has not been previously discovered. Not only have we produced the entire investigative file, but we've, in response to interrogatories, provided the detailed chart that I just described. And moreover, we understand that the people may be precluded at the trial, which is underway, as Your Honors mentioned, from relying on related party transactions that aren't described in the interrogatory.
You haven't given them enough information, then the judge could do that at the trial.
Correct. And finally, we've certified, and this is at page 205 of the record, we've certified that all non-privileged information has been disclosed. And as the special master and trial judge observed, there's an overwhelming body of authority, not just in the state court, but frankly also in the federal cases that the NRA would prefer to rely upon, that when a party has certified that all such information has been discovered, that courts are going to be very skeptical of an attempt to depose counsel. And that brings me back to Best Line Products, which is that it is, in essence, an attempt to get at the mental impressions and strategies of counsel. Thank you, Your Honors.
Thank you, counsel. 2 minutes.
Thank you, Your Honors. I'd just like to iterate that the Liberty Petroleum case is narrowly designed to prevent the disqualification of attorneys, limit wasteful depositions that are unlikely to yield admissible evidence, and avoid damaging the collective perception of the adversarial process. These are not the factors that are at issue. These are not at issue here.
Aren't you seeking a deposition of counsel, of the counsel who verified the complaint?
Not in a privileged capacity, not in terms, we are looking for the underlying facts that led to the first.
So they gave you the investigative file, and I actually, just going back a second, your adversary argues it's not an abuse of discretion, and that's a pretty high bar. We have to find an abuse of discretion. How is there an abuse of discretion? Because clearly you still have remedies before the trial court, trials going on. If the responses aren't adequate, why can't it be handled that way?
Your Honor, because there's no instance in which we can just appropriately put the AG on the stand at trial and ask the questions to get further evidence here of what we need in terms of how they got to the causes of action and the specificity of the claims there in order to
How they got to
defend
the causes of action sounds like you want their theories, their work.
the underlying facts that lack specificity.
But the facts
in
are the
complaint.
investigative file.
And how is that not privileged information? They have indicated that they have produced all non-privileged information already. So I don't understand I don't really understand, it's a
We find
semantic
the
thing.
contention interrogatory responses merely alleging, for example, the names of individuals who are subject as whistleblowers without any supporting information about the claims against those, the claims asserted by those individuals, how they were retaliated against. We find that insufficient. We find lacking a list of the related party transactions.
But there was no other way that you could have gotten this discovery other than waiting to?
We have tried through numerous different avenues to get that discovery, including seeking a trial court order to have the NYAG amend their contention interrogatories, and found those responses, even as amended.
Counsel, the one thing that I don't understand, excuse me,
No problem.
there's no dispute here that the AG commenced this action on behalf of the people of the state of New York in its protective capacity. Agreed.
Technically, under the statute.
Well, you know what? Let me phrase it this way. So that's the way I see it. So let's frame it that way. Please tell me, what authority are you relying on that if that's the case, that makes them a party rather than the attorney? What authority should we be looking at?
Sure. So looking at People v. Lefkowitz, the court there stated that when the NYAG does act in its protective capacity, where the statute that it's acting under is brought expressly in the name of the people on behalf of the state of New York, that language is not in the NPCL here, as it was in the general business law that was brought under Lefkowitz. And so that's the dispute that we see there.
Thank you.
Thank you, Your Honor. I see my time is up.
Thank you both. Tawil versus Sutton. You may proceed, counsel.
Good afternoon, Your Honor. Stephen Wagner, Cohn-Talbot, Spievak and Wagner for the appellant. There are two issues that came up at trial that we maintain are reversible error. The first issue was we had an affirmative defense of an illegal contract, which voids the contract.
So in other words, under your theory, it voids the contract and you get to keep the money?
No, there's no.
What happens to the money? What happens to the $3 million under your theory?
Our claim is we never had that money, Your Honor.
So where's the money now? Where is it sitting in Israel somewhere with the attorney? So the attorney gets the windfall?
No, but
Who gets it?
the case should have continued. They could have done their discovery, should have found the money, or not found the money, but we didn't have the money, Your Honor. So wherever the money is, it's not in my client's pocket.
Is the plaintiff seeking to enforce the fruits of an illegal contract, or is it merely seeking to recover the monies that were sent to Israel from Switzerland?
Well, Your Honor, the key question is, what was this contract? The contract was to move money from Switzerland, where it was in an account to evade taxes, into an account in Israel, where it would continue to evade taxes. There's no question about that. That was the contract. Now, they're claiming that the contract was, well, I want you to really manage my money. And since you didn't manage my money properly, I want...
So there is really a question about what was it's an oral contract that we're talking about, right?
Correct.
So we have problems sometimes with oral contracts. It did seem to me to be there was a dispute as to exactly what the contract was for. You've already given two scenarios, and who the contract was between.
That is correct, Your Honor.
So
that's actually my second point about the dead man statute. But in the first point about the illegal contract, I was not permitted to put on any evidence about the illegal contract, and it came as a result of a motion in limine as opposed to a motion for summary judgment. Now, had they moved for summary judgment on the affirmative defense...
Well, they had moved. They already moved for summary judgment. No, they moved initially for summary judgment.
But not to dismiss the fourth affirmative defense. So had the
But wasn't it raised in the motion for summary judgment?
No, Your Honor. They made a motion of summary judgment. I raised the issue in my response.
And the court didn't address
And
it.
the court didn't address it at all. Now, had the court addressed it in the motion of summary judgment, had they raised it and the court addressed it, then I would have appealed, and then it would have been not abuse of discretion. It would have been.
So rather than that, it was raised in a motion in limine, and now you're appealing it.
And now I'm appealing that, but it could be a different standard. But I'm saying that it should not be the standard of abuse of discretion. It should be the standard for regular summary judgment, which is error. And because that's essentially what he did. And this court has said over and over and over again that is not the proper procedure to dismiss a claim or an affirmative defense, which is what happened here.
Counsel, if I may, what's the relevance to this alleged illegality? I mean, what's the relevance here?
Then the contract would not be enforceable.
And the reason why I'm asking that is because, you know, when you look at the stipulated facts, there's no dispute. The transfer of the $2 million in Switzerland to the bank account in Israel, right? And then the various exchanges regarding the return. So, as my colleague said, this is about the return of monies that were transferred. So what does that have to do with anything? I don't get it.
The whole case was that there was a breach of a contract between Mr. Towell and what they ultimately said was my client, Isaac Sutton, as opposed to his father. That claim...
What's the breach of contract? I don't even see a breach of contract. It's monies hadn't received, monies that were transferred from Switzerland to Israel, and now the estate is demanding that, hey, return my monies.
No, I understand, Your Honor.
That's all it is.
Yeah, but they sued my client for that. My client didn't have the money.
That's an issue for trial. That's an issue for the jury. It's not an issue. It's not an issue that certainly we're going to opine on at this point, right?
No, absolutely, Your Honor. But what I'm saying is that they're not entitled to bring their breach of contract action because that contract was for an illegal purpose.
So take breach, as Justice Singh was indicating, and Justice Kennedy, take breach of the contract out. You would still have unjust enrichment, money hadn't received. There's still an underlying sum of money that wasn't generated by illegality. Maybe it was moved around for certain tax avoidance purposes. But there is an underlying sum of money that they're saying that needs to be returned. Right. That was that's irrespective of any illegality.
So, Your Honor, one thing I'll say, not tax avoidance, but tax evasion. Tax evasion is absolutely illegal, all the decisions in this court.
So in other words, I'm sorry, go ahead.
Normally, illegality goes to like malum in se type crimes. This is sort of a regulatory malum in prohibitum type crime. Is this really what that doctrine is meant to?
I believe so because there are cases on point that we cite that tax evasion, contracts for tax evasion are not enforceable. So if you don't have the enforceability of the contract, the case disappears against my client, and I had the right, I should have had the right to raise that at trial. In the last 2 minutes, Your Honor, if I can go to the dead man statute, I don't think there's any question that the judge misapplied the dead man statute. The estate didn't raise it. There's no question about it.
So the question I guess I have with respect to that, and I don't think you're wrong about that, is wasn't the error harmless? Because what does it matter?
No, it was not harmless, Your Honor. I had an entire defense based upon conversations that my client had with his father. His father was, without question, that was absolutely stipulated, the person in that community that people went to.
But the father was dismissed from the lawsuit in 2019.
The estate was dismissed later. Right?
So how can you blame the father now when the estate's out of the case?
No, it wasn't. I wasn't blaming the father. I was trying to put into context what my client was doing and what his involvement was. The judge did not allow me to do that, and it was not harmless error. It was very, very material.
Can you hold your fire for reply?
I'm sorry, Your Honor?
Can you hold your fire for reply? The red light's on.
Absolutely. Thank you, Your Honor.
May it please the court, I'm Michael Massery, counsel for respondent. When you look at everything in the context of the fact that the the Mayor Sutton claims were dismissed. The court has already ruled that Mayor Sutton is not liable and did not breach any contract. Counsel has suggested that he would have put on so much, he would have introduced so much additional evidence beyond the evidence that he already introduced because counsel wanted to indicate what was really going on here. The record mentions Mayor Sutton 14 times, and it was repeatedly discussed. And in that regard, the the defendant had an opportunity to testify at 327 of the record. Why did you assist in getting this money back from Israel to the Tawils? For one, my father asked me to help them. I'm trying to help my father. He was in a very bad position. He was not capable of doing these things. There's 14 different instances.
Are you trying to enforce an illegal contract?
No, Your Honor, I'm not
So
trying.
why is it? Because clearly, and I understand the taxes were paid on that, but putting that issue aside, why is it you're not enforcing an illegal contract to evade taxes?
There's no credible testimony that they would have been able to introduce that it was a contract to evade taxes, Judge. It was a money management agreement. The terms were very clearly set forth in the documentation that was before.
But your adversary argues, obviously the money was offshore, so you wouldn't pay, your client wouldn't, or the father wouldn't have to pay taxes on it.
There would have been no evidence that it would have been moot. It would have been futile because there was going to be no evidence for him to introduce. Because, Judge, just because the money's offshore doesn't mean that that the money itself is illegal. There's programs that you can bring monies
So
back.
if we were to agree with counsel that the contract was illegal, what would happen to the money? Would there be a windfall in this case?
It totally would be a windfall.
Who would get the windfall?
Judge, the windfall would go to the defendant, Isaac Sutton, because Isaac Sutton's attorney testified by deposition on written questions. He said, I'm the attorney for Isaac Sutton. I'm also the attorney for Mayor. I worked on some deals for Mayor, but anything that I did for Isaac Sutton is privileged. And there was no way that we were going to be able to force counsel in Israel to testify beyond that. This was a shell game, Judge. The fact that this is still going on, it's just a continuing shell game. I see that my time has been used up, Your Honor, unless there are any other questions.
Thank you, counsel. You got 3 minutes, counsel.
Thank you, Your Honor. First of all, there was ample testimony about the illegal nature of the contract based on the deposition.
Counsel, this case is really about showing where the money is, right? Wanting the money back, not about a contract for money management, but to return the money, show the money, right?
Yes. They wanted the money back, no
Right.
question about it.
It's their money. Why shouldn't they get it back?
I'm not saying that they shouldn't get it back. What I'm saying is they can't sue my client in breach of contract on an illegal contract. And that's what they did.
What about the other claims that they have? When they sued you on more than just breach of contract, no?
Yes, but the primary claim was breach of contract.
It's not your money, right? You agree it's not your money?
Of course it's not my money.
So then they're entitled to the money back. It's that simple. I just don't understand why we had to go through a full trial for that.
And they should get their money back. My client never had the money. That was the whole purpose of the trial. What they were trying to do was prove that my client had the money. Had I had an opportunity to defend those cases, those claims.
Well, the way you could show is that there's no account under your name. Presumably, you put in all the documents from Israel, and then the jury made its decision, right?
But, Your Honor, I was not able to put the context in of his involvement.
But the context doesn't matter, right? The context doesn't matter about an illegal contract. What matters is about the money and getting the money back. And if your client doesn't have the money, then you put in evidence to show that that money is not available and your client doesn't have the money.
Right. The evidence, Your Honor, was they had email correspondence between his client and my client. My client did respond to that email correspondence. The jury got the impression that my client was in control of the money. Had I had an opportunity to put in evidence, I would have shown this not on the illegal nature of the contract. That's a different issue. But if I had the ability to put in testimony with regard to what his involvement was, I would have been able to defend this case.
So who should the judgment be against?
The person that has the money. I don't know who has the money. They've never found the money. I don't know where the money is. So it should be against the person that has the money, not against my client. But I understand what the jury
Doesn't
found.
that sound like a shell game? Sounds like a shell game to me, that it's, well, the money is under three-card Monte here.
Your Honor, it's not a shell game with regard to my client. Client has a judgment against him. So it's not a shell game. The point is he didn't have the money, and I was not given the opportunity to explain that. I also was not given the opportunity to show that this was an illegal contract. The contract itself was illegal. So whatever they did with regard
I
to...
don't understand. Why did you not have an opportunity to show, not about the illegality, I get that, but where the money was? I mean,
No,
you
where
didn't
the
have
money
a chance
was-
to defend this case?
Yeah, no, Your Honor, my client testified he didn't know where the money was. This lawyer in Israel, there's some misunderstanding here. The lawyer in Israel did represent my client, and he represented the client's father.
Right.
No question about that. What they tried to say is, well, he was representing you in this transaction. That wasn't the case. But I wasn't able to...
But there was testimony contrary to that point, because I think that counsel for the father believed or testified, in fact, that there was such a representation, correct?
No, I don't think so, Your Honor.
Okay.
I don't think so.
Okay. Okay, thank you.
Thank you very much, Your Honor.
Rodriguez versus Miller Plumbing.
Good afternoon, Your Honors. May it please the Court. Scott Horn, counsel representing the plaintiff appellant in this matter. It's our contention, Your Honors, that the motion court erred in awarding summary judgment to the defendant on the grounds that it owed no duty to plaintiff as a matter of law. Specifically, we submit the defendant failed to meet its prima facie burden on summary judgment because it failed to submit the agreement, the contract, which governed its duties and obligations at the premises. In moving for summary judgment, the defendant submitted Exhibits A through X, but omitted the agreement, the germane agreement, which governed their conduct at the premises. Now, there are numerous precedents which support the conclusion that the failure to submit the operative agreement requires the conclusion that the moving party on a no-duty argument failed to meet their prima facie burden. And specifically, I'm referring to the Calabro case, which is from the Second Department, the Camera case from this court, Justices Kapnick and Higgett both sat on camera, and the Aghali case, also from this court, Justices Kapnick and Singh sat on that decision.
So it's your position that the third exception of Espinal applies? Is that what you're arguing?
No, Your Honor. I'm
not even arguing Espinal.
You're saying they didn't even get there.
You don't even get there. You don't even get to Espinal. So you only get to Espinal if it's not established that there was a duty direct owing to a particular party, right? So the snowplow contractor, right? That's a classic example. The snowplow contractor has no connection to the person who falls in the parking lot because the snowplow contractor is just there to plow the parking lot. Here, what we have is we have a comprehensive agreement by which the defendant undertook to, number one, act as the, quote, agent, unquote, of the owner in connection with this construction project, and it outlined a comprehensive set of responsibilities that they were required to fulfill.
It sounds like you are arguing the third exception of Espinal.
Well, again, I don't think we get there for two reasons. One, because they didn't meet their prima facie burden on the no-duty point, so you don't even get to Espinal. And two, Espinal wasn't even argued in the lower court by the defendant. The Espinal issue was not even developed in these papers. So that Espinal argument would be unpreserved even if it was properly raised at this point by the defendant, I would respectfully submit that on the duty.
Okay, so let's just assume for a second. Let's cut you off. Let's assume for argument's sake there is a duty. Okay.
Yes.
But you still have to show notice. How have you showed notice in this case?
Well, I think we're putting the cart before the horse, Your Honor. So when we're dealing with a premises defect, the person in charge and responsible and in control of the premises has the prima facie burden of establishing a lack of notice.
How is Hudson? They're a construction manager, right?
Correct.
They weren't on the 15th floor at the time of the plaintiff's accident. I mean, I think they were finished. I know, and they were they didn't control, own, occupy, or make use of this location. I don't know how they can be responsible for this situation.
So what are we talking?
The owner is the owner, and of course the owner is the employer, I think, in this case, so they're not in the case.
Are we talking about now the duty question or the notice question? Because if we're talking about the duty question, I think that the issue is clearly determined on the prima facie issue. So they're brought in to control, manage, and operate the premises, right? It's like a managing agent in a residential.
But let's just get beyond that for a second. I'm focusing on notice. Okay, it's a latent defect. Latent defect, right? So did they create any issues of fact as to whether they created this defect? I don't think so. It's only constructive notice.
Correct.
So what is the constructive notice here?
There's a lack of a prima facie showing that they undertook the inspections that are required
How are
under
you
the
going to
contract.
inspect a latent defect?
Well,
What are you
who's to
supposed
say?
to do?
They don't know it's a latent defect. I don't know it's a latent defect. You don't know if it's a latent defect. All we know is...
Based on the testimony of your client, are you telling me that it wasn't a latent defect?
I have absolutely no idea if it was a latent defect, Your Honor. My client was a cleaning person. She's
Did your client see a
Windexing
crack
window.
in the glass, for example? Did she see a crack in the frame, for example? I don't think so.
No, of course not. Or I shouldn't say of course not, but no, that's not the case.
So
But
it's
that
a
doesn't make it a latent defect, Your Honor, especially when one party, i.e. the defendant, is charged with the responsibility of undertaking an inspection of the work that was being performed. And perhaps it was completed, perhaps it wasn't, to Judge Kapnick's point.
Yeah, but
You know,
I don't
this
think,
is a
I
situation.
don't think it's, I think that's not disputed. Your client, in fact, testified that she didn't see any construction workers, et cetera, et cetera, et cetera there. So I don't think there's a dispute about that.
I disagree, Your Honor.
Okay, fair enough.
And the point that I would make, if I may just complete this point, is that the defendants moved for summary judgment, right? It should have been easy for them to determine, to show prima facie that they owed no duty and that this is when we left the site. This is when we turned the site back over. They produced nothing in the form of the contract. They produced nothing in the form of any work records, and the person that they produced to testify knew absolutely nothing about the project, was able to find no records from the project, and was never even at the premises at any point in time during the project. So on balance, Your Honor, the point on that being that if they're going to move for summary judgment and they're going to rely on the plaintiff's testimony, which is what they did, they have to rely on all of the plaintiff's testimony. So while Your Honor pointed out that there may have been instances where they essentially cross-examined her on that point, she also specifically testified at page 806, 807 of the record, quote, "There was construction going on, so there was a lot of dust, and that's why they hired me to clean that," unquote. Page 575
But that
of the record.
doesn't mean that there were construction workers there. All there was is dust, right?
But the point, Your Honor, is that the construction work, whether it was literally ongoing while she was undertaking the cleaning or whether her cleaning was part of dealing with the construction, is immaterial in the context of this analysis.
Okay, well, why don't you save the rest for...
Thank you, Your Honor.
Good afternoon. Paul Lemo for the respondent appellant. Appellant relies on the contract and says the contract governs this. But the fact of the matter is the contract that he's referring to has nothing to do with the installation of the valances on the 15th floor.
Your client didn't install that. Your client did not install those.
That's
glass doors.
correct.
They didn't manufacture and they didn't install them.
My client was the construction manager, did not manufacture, design, or install. It was done by another company hired directly by the tenant Halstead, who had a direct contract with Infinium, the third-party plaintiff, which we have cross-claims against.
Well, I
for-
suppose your adversary would say, even if that's correct, you still owe a duty. You haven't established prima facie that there was no duty owed because you didn't provide the contract.
I missed the first part of your comment.
That you didn't make out a prima facie case because you didn't provide enough of your contract to establish that no duty was owed under the contract. That's their position.
Understood, but the contract that was relied upon by the appellant had to do with had to do with work done on the 14th and 15th for the interior build-out, and the item in question that fell on the plaintiff was not governed by that contract.
What about? I'm sorry. Go ahead.
Wasn't the best evidence of your client's contractual duties the construction management contract itself?
The best evidence for the work that applied to the scope of the work that we were doing, not for the scope of the work where the alleged incident occurred, which was the installation of the valances. We submitted documentation as to the Infinium contract with the tenant, which governed the very item that's being alleged as defective. We submitted documentation that showed that it was paid for by the tenant. It was billed by Infinium. We also submitted records,
No, I understand that, but if
inspection records from us.
Your adversary's position, sir, that without the underlying contract, i.e. the best evidence of what you did as opposed to what others did, is lacking, and that's why you don't make out a prima facie. But in any event, do you want to address the issue, if we were to say there was a duty here, do you want to address the issue of notice?
In terms of notice, well, as it's our contention based on the testimony, and even in the testimony that we had completed our work, and there was nothing. The plaintiff's own testimony was that she didn't know how that balance fell.
But that doesn't mean that if you had inspected it, you might not have seen something. I mean, I keep thinking about the bolts that fell out of this airplane.
Well,
And if somebody
exactly.
inspects it, maybe they'd see that there was something, even though we thought it was latent. Maybe it wasn't. Maybe if it was inspected, they would have seen something. Just because she had cleaned it before and that day it fell doesn't mean.
There were no bolts. There was nothing other than this valance. There was no bolts. There's no cracks. She testified she didn't see any of that. She had worked in that office the whole week. She didn't notice anything wrong with it. Made no complaints to anyone about it.
Thank you, counsel.
Thanks.
Very briefly, Your Honors. On the threshold issue, there was no response that I heard that answers the question of how you meet your prima facie burden in the absence of producing the contract. And I would implore the courts to look at the cases that I referred to in my opening presentation, the Camera case in particular.
But it's really not disputed that the contract to do the glass and the valances was not with the construction manager. Those were separate contracts. So why would there be a duty under those sorts?
All of the work was under separate contracts, Your Honor. All of the work was under separate contracts. They were the construction manager. They stood in the shoes of the owner overseeing the project.
Was there,
The 14th and
was there a
15th
contract between the owner and the construction manager?
Yes.
Did you get that contract?
That's the contract that they neglected to
That's
submit.
the contract you're looking at. You're saying
Yeah.
that they took over the rule.
That's correct. Look at the contract. There's a reason why they didn't put it in further into their motion for summary judgment, right? A through X. There's a reason. The reason is because it says they're the agent of the owner.
Okay, and so the contract with Infinium, that was with his client?
No, with the, my understanding is directly between the owner and Infinium, but it's part of the whole project that's being managed and overseen by his client. And again, we're only having this conversation because of what came up after the motion for summary judgment was made. On the prima facie, in moving for summary judgment, they did not submit the document which outlines what their obligations were. So again, like a managing agent situation, so this is not a snowplow situation. This is not me trying to sue Infinium or anybody else that was on the premises. This is suing the person that was responsible for managing and inspecting in the shoes of the plaintiff, and for that, in the shoes of the owner rather. And for that reason, like a managing agent, the Agley case, 195 AD 3rd 458, and the Camera case, 210 AD 3rd 501, these are the cases that control on the prima facie issue. If there are, I'm sorry.
I just want to go back because you're saying that they were the agent, right? Now, did you allege that? Because I know in Calibro, I mean, that was the issue there, the managing agent, right? Yes or no?
I'm sorry, in Camera, yes, it was a managing agent.
Okay,
Yes.
right. So here, no allegations about that they were the managing agent, right?
Well, I don't know how to answer that. So,
no.
meaning in the bill of
You can
particulars?
you can go to the complainant and look, you either alleged it or you didn't. I don't think you did, but stick with me here. Because isn't it true? I mean, Hudson, you know, they solicited bids, they coordinated the trades. There was no indication about management. You can look right now at your complaint and tell me if you alleged it, because I don't think you did.
I'm not sure about the agency, but I can assert that we did allege that they were responsible for supervising and control and managing the premises.
think so. That's
And the management agreement itself, Your Honor, goes way beyond just simply
Yeah, they coordinated the
items.
trades, they oversaw the general contractors, but they weren't responsible for directing the trades.
I would implore that you look at page 2296 of the record, which is the scope of services. It's a full page, itemized, single-spaced, and included there are inspections, site safety. There's even post-construction services before they even turn the premises back over to Hallstatt. So that's why it's a red herring to say, well, there were no construction workers on the date that she was injured, because they were still responsible even after that, because they were responsible for 1, 2, 3, 4, 5 different items.
You were claiming that at least potentially they stood in the shoes of Halstead for this case until they produced the document to prove otherwise. It's at least they haven't made out the prima facie case. Is that?
I think that's clear, Your Honor. I think that's clear, and I think that under the circumstances, when you look at the agreement that was ultimately produced, putting aside the prima facie issue, that there's at a minimum a tribal issue of fact on that, even if they met their prima facie burden. And once we establish that, Your Honor, getting back to notice, once we establish that, it becomes incumbent upon them in moving for summary judgment to show that I inspected this, I inspected it on this date, or I had an inspection regime in place that was reasonable. Nothing. There's not a single work log that they produced as part of this case when their witness came in to be deposed that shows what they did at all in this case. But what we do know is that inspection and management and control and all of these things were part and parcel of what their responsibilities were.
You know, the record in 60, right, that Hudson maintained a contract with respect to the performance of certain construction work on the premises. That's why I posed that question.
I'm sorry, Your Honor, page 60? Is that in the complaint?
Yes.
Okay. And so, you know, the point is that...
Are my contacts fooling me? Are they fooling me? 'Cause I think, you know. Are they fooling me?
No, Your Honor, your contacts are not failing.
All right.
But the idea is that when we look at the allegations against the owner, it talks about, you know, their agents. And in this instance, their agent was, in fact, in writing, by contract, their agent was the defendant. Right. If there are no further questions, I'll rely on my papers. Thank you so much.
Thank you, counsel. Thank you both. Jason V. Ma.
Good afternoon, Your Honors. May it please the Court, John Sullivan for appellants. Appellants respectfully submit that the lower court's decision denying its motion to dismiss was error. Specifically, the 2019 email referenced in our papers from Plaintiff Edelstein to Defendant Yin.
When did you first provide the 2019 email?
In the reply.
So is that something we should consider under the circumstances? Because your adversary didn't have an opportunity down below to address that email. You only relied upon earlier emails.
Your Honor, plaintiff opened the door to the 2019 email by submitting sworn testimony from plaintiffs stating expressly that Defendant Yin did not provide any services for 7th Online from 2010.
But how is that a new argument? It was your position based on emails that you provided. Plaintiff just responded to your argument. Wouldn't it have been incumbent upon you to provide all the emails, make your arguments, let them respond, and then you reply?
I think in an ideal situation, that is what would have happened. I think what happened here was that the initial emails weren't available. 7th Online is a very small company, and obtaining the emails took some time. And I think that is what happened here. Nevertheless, the email exists.
It was your motion to dismiss. So you could have marshaled, and you're moving on 3211A1 grounds. So isn't it incumbent upon you to marshal all your evidence before you make the motion?
I agree completely, Your Honor. The counsel that did this motion, prior counsel, should have done that. Nevertheless, I think the 2019 email is still permissible to be reviewed here because it directly refutes the sworn testimony.
Well, does it utterly refute all their claims? I guess isn't that the standard? It's utterly refute.
That is the standard, Your Honor. It doesn't utterly refute, but it does utterly refute the claims with regard to not providing any services and not being paid, at least until 2019.
I took a look at that email a few times. It didn't seem that that email was that clear about what it meant. You know, we missed the payroll, you'll get a check, but then you'll pay us back and we'll make it up. And I'm not really sure what it meant. I found it confusing, personally.
I understand your confusion. I think the use of the word payroll, though, expressly means payment for wages. And so to say that we missed the payroll, we'll forward you money now, and you'll pay it back later, I think that indicates, at least to me, Your Honor, that that email contemplated payment of wages.
But it doesn't utterly refute the issues raised.
Your Honor, I think there is still, missed for the grist for the mill with regard to payment of wages past that time, but I think it does, from 2019 at least, up until that time. The plaintiffs in their sworn testimony, sworn affidavit, said that they were not aware of any payment to Yin. This directly refutes that. But in addition to that, plaintiffs' breach of fiduciary duty claims are time barred, at least to the extent they arise from conduct that occurred before June 24th, 2019. And many of plaintiffs' causes of action are duplicative. Going to the breach of fiduciary duty claims, there's a different standard, statute of limitations for breach of fiduciary duty, depending upon the relief sought.
The relief sought here, is it primarily monetary, or is it a mixed question of monetary and equitable relief?
It's mixed, but it's primarily monetary, $24 million in damages. There is some equitable relief, but it's ancillary.
And there's really no fraud alleged in terms of the breach of fiduciary duty, is there?
That's exactly right.
That could have extended it to the 6-year statute of limitations, but you're saying they're really, there's a lot of causes of action, but I don't think any of them are for fraud, so that it would sort of knock it back to the 3-year statute.
You're exactly right, Your Honor. The word fraud not only doesn't appear as a cause of action, it doesn't appear at all in the complaint.
But this would not knock out everything. This might knock out something.
Exactly right, Your Honor.
But can we at this juncture say, assuming we were to agree with you that it's a 3-year statute of limitations, can we really say at this juncture what claims it knocks out, what claims still remain? Isn't that something that needs to be developed below?
I think we can say, I think there is a portion that needs to be developed below, but I think we can definitely say that with regard to payment of wages that occurred from, prior to 2019. Plaintiffs allege that there was unpaid wrongfully paid wages beginning in
Couldn't the
2012.
plaintiffs argue that there's a continuing wrong going on, and therefore they should be able to go back further?
Yeah, we addressed this in our reply brief. The continuing wrong doctrine really only applies when it's the same continuing wrong. Here we have different types of wrongs, discrete acts, and that's why we think that doesn't apply. Thank you very much.
Thank you.
Good afternoon, Your Honor. Stephen Arena, may it please the court, Stephen Arena for respondents and plaintiffs Edelstein and Chazen, derivatively on behalf of 7th Online. This case arises out of massive mismanagement by the defendants and their misappropriation and diversion of corporate assets. It also arises out of their scheme.
Do you want to address the emails, counsel?
Sure. I mean, Your Honors have said they're completely ambiguous. If you look at the first email in the chain, and this is the email that was provided in reply where we had no ability to provide context, but if you just look at the email on its face.
2019 one.
That's correct, the 2019 email. It's an email from defendant Dan Yin from her personal email account, not her work email account, her personal email account to her husband, Max Ma, asking for payment from him. That context is completely unclear. Plaintiffs would love to provide that context in rebuttal or through discovery. It just doesn't make sense, and we could help with that. We should have an opportunity to do that. We're at the pleading stage, and it doesn't utter, as Your Honors have said, it does not utterly refute anything in this matter. It's completely unclear. What is not ambiguous are the 3 sworn affidavits that state that Dan Yin did not work and during that 10-year period. That email doesn't relate to anything to do with work. She may have been
payroll.
paid.
Why payroll suggests work to me, at least. Making payroll, getting paid for the work you do.
That's again, we can't provide the context because it's outside of the record, but that's not necessarily the case. As we did point out in the record, plaintiff Chaim Edelstein was trying to help mediate certain situations between the husband and wife. And I don't really have anything other than that I can say that's outside of the record.
How about the statute of limitations? What's your view of that?
As Your Honor pointed out, these claims amount to a continuing wrong. You have payment after payment after payment to Dan Yin. It is the same claim over and over again that goes back to the beginning.
You're alleging payments over all those years, from starting 2012 all the way through.
All the way to the present, and those claims are told to the last wrongful act, which is up until the time of the complaint. In addition, these claims sound in fraud. Although we don't have a claim for fraud, all they have to do is sound in fraud. These are claims arising out of a manufactured regime change to silence the plaintiffs and to conceal wrongful conduct from the shareholders. There are allegations regarding the manipulation of corporate records, of denying access.
It's misappropriation, breach of the shareholders' agreements. That doesn't sound in fraud.
Well, we have manipulation of corporate records. We have denying access to account statements and accounts so you can see where these disbursements were being made.
That's a breach of the shareholders' agreement, right?
Well, I'm referring to breaches of fiduciary duty. So the Mr. Ma, as the CEO, had fiduciary duties to the company, had duties of disclosure, and he had violated those duties. And if you have a duty of disclosure and you fail to disclose with the intent to conceal wrongful conduct, that amounts to actionable fraud. And that's all that is necessary for the plaintiffs to get the opportunity to utilize the discovery rule to discover the fraud, and the statute of limitations would accrue at that time of discovery, which was well within the 2 years of the filing of the complaint. With respect to the duplicative claims, if Your Honor would like me to get into that, they are not duplicative of the breaches of fiduciary duty. Number one, the faithless servant claim seeks a different relief. They're seeking the back salary from Max Ma from his first wrongful act. That's disgorgement. That's a $2 million claim versus the $8 million claim in diversion of assets. The unjust enrichment and the money hadn't received claim are only against Dan Yin. And there is no claim for breach of fiduciary duty against Dan Yin. So you have different parties and different claims. There's no duplication there. With respect to the breach of contract claims, those arise out of different duties associated with the shareholders agreement, duties associated with the bylaws, duties associated with resolutions, in particular the resolution that Mr. Ma would not make expenditures in excess of $1,000 without approval of the board. The misappropriation and diversion claims and waste and mismanagement, they don't require an element of the perpetrator to be a fiduciary. Anybody can, any low-level employee can engage in misappropriation and diversion. It's a different cause of action. With respect to the direct breaches of fiduciary duty by the new board members and the aiding and abetting breaches of fiduciary duty, the direct breaches relate to those board members' failures to provide information, their failures to provide investigation in connection with the wrongful conduct. That was their affirmative duties. With respect to the aiding and abetting, you don't have to be a fiduciary to aid and abet.
Finish up.
They helped Mr. Ma conceal his wrongful conduct and to engage in the wrongful conduct. Thank you, Your Honor.
Counsel? 2 minutes.
Thank you, Your Honors. Going to the statute of limitations regarding breach of fiduciary duty, like we said, not only is fraud not expressly alleged in the complaint, they also don't allege the elements of fraud. There's no allegation of justifiable reliance. And so in that way, you can't find that fraud was alleged in any way. Going to the duplicative causes of action, it isn't appellant's contention that breach of fiduciary duty cause of action is duplicative against every other cause of action. If you can see in the brief, we actually say that certain causes of action are duplicative of certain groups. And it's not the theory of the cause of action, the underlying theory, that is relevant, but rather whether the causes of action arise from the same alleged conduct and seek the same damages. And so as you can see from the copied and pasted allegations in the complaint, many of the causes of action arise from the same alleged wrongful conduct, and they seek the same $8 million or so in damages. And so because of that, we say these causes of action are duplicative, and not merely allegations pleading in the alternative, which is what is argued. If there are no other questions, we'll rely on our brief. Thank you.
Thank you, counsel. Thank you both. Sylvian Hospitality.
Yeah, may it please the court, Michael Siegel, Siegel & Siegel PC for the appellant, Sylvan Hospitality, which is the tenant restaurant in this case. Essentially, if this case were being argued 500 years ago, 100 years ago, or even up until very recently, there'd be no debate here. Everyone would have conceded since the earliest common property law days in England that a lease was real property, that the conveyance of a lease, a term of years, was a portion of...
We have to grapple with PK.
Right. So we are here, right, because of two things. First of all, the judge below misinterpreted PK. PK was a case where the tenant, equivalent to my client, had already been evicted, had surrendered the premises, had given in the keys, and conceded that they had no interest in the real property. Then the landlord rented it to somebody else. Then the tenant, who was in my client's position, brought a case to get their leasehold back after it had already been terminated. So we can all agree that if you have a judicially decreed termination of a tenancy, then wait time...
But why judicial? Well, wasn't the tenancy terminated by the termination notices, and was a Yellowstone injunction obtained?
No, so
if that's the case, isn't the tenancy by operation of law, based on failure to respond to the termination notices, isn't it the same situation as PK, where you don't have an interest in the leasehold based on that termination?
No, because you could always fight in landlord-tenant court about whether the termination was wrongful or improper, which is what there are two terminations here. The first termination, we were in landlord-tenant court fighting about the propriety of the termination and entered into an agreement to make a stipulation, which because of COVID never happened. So the case was marked settled by stipulation, but there never was a stipulation. But there never
Then there
was
was a flood, right? There was a flood in the premises?
Right. So then,
And then there was
then
another
COVID.
termination.
Right. COVID closed the restaurant. Then my client came back in without the hotel being open when you could operate restaurants, but the hotel never reopened. Then there was a flood on an upper floor, clearly undisputed. My client had nothing to do with it. They just befell the burden of the damages of the water ruining their place. And then.
So, but importantly, there was a termination notice served pursuant to the lease.
Right, but a Yellowstone injunction is for when the tenant has a non-monetary default that they want to have cured and they're in compliance with their monetary obligations. Here, my client wasn't in default at all. The issue dealt with a flood that clearly wasn't anything to do with my client, and we are now fighting the notice of termination.
If they serve a termination notice, they did it pursuant to, I understood, a clause in the lease or provision in the lease that allowed them to do that if they felt that the damage to the property was so bad that you couldn't stay in there. So they filed a notice of termination pursuant to that, and there was a termination date. Didn't you have to do something before that termination date, like a Yellowstone or some kind of relief from the court to stay the termination date? Because once the termination date goes, it's really tough.
No, because this case is about whether the termination was properly done. There was no determination that the termination was proper. It was the landlord's unilateral statement of termination. And the other argument that we made in the papers is that they already said they terminated once, and then they said, now we're terminating again. They can't be maintaining the position in Part 52 civil court that they already had a termination, and then maintain that, no, there wasn't a termination. Now, several years later, we're going to come back and do another maintain that, no, there wasn't a termination. Now, several years later, we're going to come back and do another termination.
Well, wouldn't that suggest maybe that the first termination was vitiated by the second termination notice? But they served you with the second termination notice saying that in their business judgment, the repairs couldn't be made within 180 days. You didn't get a Yellowstone injunction. Maybe you can fight the issue with respect to that, but as a matter of law, isn't your interest at this point terminated because you don't have an automatic right to cure?
No, but we're not the ones curing. They're the ones that they're the ones that say that we can't repair in 180 days. Right. And the issue in this case, the ultimate issue in this case, will be whether that termination was proper, was done under the lease, whether they caused the flood or not, and whether it was all a ruse just to get rid of the lease. That's still for trial. The case still exists, right? The issue for this appeal is whether or not there's an interest in real property that we can file a notice of pendency and maintain a quiet title action on, and the answer to that is yes.
Okay, thank you. Let's hear from your adversary, and then you'll have an opportunity to respond.
Good afternoon. I'm Peter Shapiro from Louis Brisbois, attorney for the respondent. I believe that Your Honor's questions have been very on point in terms of what we're dealing with here.
Well, what about their argument, which kind of makes sense, that normally Yellowstone is something that we did. You go get a Yellowstone injunction, and you meet the criteria. Here, it's not us. We did nothing. You guys created a flood, and we don't agree that it can't be repaired within 180 days.
Well, I will concede that a Yellowstone injunction was conceived for the purpose of enabling a tenant to get a timeout so that it can cure. But we still have a situation here where a tenant is faced with an eviction pursuant to a notice, which it seems to think is not legit. And under the circumstances, they should be find it incumbent upon them to go to court and say, stop this. This leasehold is important to us. They didn't do anything. The fact is that this was a devastating flood. The premises were a complete wreck, not just the restaurant, but much of the hotel, and unfortunately still are. The restaurant portion still is. And under the circumstances, there was no question that my client was entitled to avail itself of paragraph 22 of the lease. There was no way in their judgment, as Your Honor put it, that could be fixed within 180 days. So the lease was terminated. That's really the end of the story in terms of this tenant having any kind of enforceable
So
interest.
in other words, they can't litigate the issue with respect to the 180 days, that in fact it could have been fixed, or you manufacture the situation, or whatever their defenses would be to that.
Well, I think not. I think what they can do is file a breach of contract claim, which they've done, and that the lower court sustained, saying basically you breached our lease and we sunk a lot of money into this space and so forth, and we're entitled to get that back. But at this point, they can't recover possession. I would also point out the timing that we're talking about here. This lease was originally terminated in 2019, then again in 2021.
But you never papered it. I mean.
Well, the eviction action in the landlord-tenant court was never completed.
Right.
So our contention is the lease was never reinstated. But it was never.
But you did
I
another
wasn't
one
judicially.
anyway, so it's like so would you go through the whole second point, the whole second situation of notice of termination and based on the flood, if you thought the lease was already terminated from the first time?
Well, that's why if you look at the notice of termination, the second notice of termination, it says it's the landlord's position that the lease was terminated previously, but to the extent that's in dispute, it's terminated now because there's no ability to restore the tenant to
So
possession.
they don't have a right to litigate any of those issues that maybe you don't have the right to terminate it twice if it was terminated once. All those, they don't have a right to litigate any of those defenses to these.
I don't think they do. I think the only issue is going to be whether they're entitled to any damages because of
In other words, your
any breach
position is
of
they can't
lease.
be restored to possession because the lease has been terminated, and that's the end of the lease.
Yeah, and and at this point, they've been out of possession for a long time. They haven't really sued to recover possession. They've just sued for damages. They asked for a quiet title, but under the circumstances, given the passage of time, and think about it.
So you said there's another lawsuit where they're suing for damages?
Well, no, there was two lawsuits about damages for the flood. One commenced by the plaintiff's insurance company, one commenced by the plaintiff. Those are now settled. That happened after the record here was completed, but you can take judicial notice of it. I don't think it really makes any difference. Those are just really damages from the flood, and the issue here is damages because of supposed breach of lease and not providing a restoration to possession. And they've been out now since just coming up on 3 years, and time has marched on, and there's no way to restore them to possession at this point.
Is the hotel functioning?
There's a new lease for the hotel. My client's not operating it. The lessee is operating it, and the restaurant space is still, unfortunately, not operational. Unless you have any further questions, I'll yield.
Thank you, counsel. 2 minutes, sir.
Yeah, my very brief point on this is if the decision is that leases are personalty for all purposes, it would be not only changing the common law, but really putting a very unequal bargaining power on typically the stronger party in the landlord-tenant relationship, giving landlords tremendous.
Well, in commercial leases, isn't that always the case?
No, it's not always the case. Again, leases are interested realty. You should be able to bring qualified title action.
But the question really is, though, is what's the effect of the termination? So does that bring it under PK?
Right. So again, on the Yellowstone point, Yellowstone is for when a tenant, like let's say, doesn't have insurance.
Okay, so it's not
or
a
breaches-
Yellowstone injunction, but you still didn't you
Right,
need then
so-
just
so
a injunction under CPLR to enjoin the termination of the lease?
Right. So we protested termination of the lease in emails and letters, but to say that the tenant has, for the landlord sending a half-page notice of termination, the tenant has to spend $10,000 in attorney's fees in order to show cause, that's not what the law is either. And that would also be a creation of very unequal bargaining power and give landlords rights that they don't have. The landlord has to go to court to effect the termination by doing an eviction, and you can claim that the termination notice was ineffective on any number of bases, including on the merits, the manner it was served, the manner it was done. I mean, you always are able to challenge in landlord-tenant court a notice of termination, as we did in the first one, and settled. That is, there was no judgment that the eviction was proper, or the possession was vacated because of the termination. Had they brought a second eviction action, we would have done the same thing. But again, they went with the sale of the property because of the flood and the fact that we couldn't get back into the premises. Thank you.
Thank you, Counsel. DB 232 Siegel, Mez versus Moskowitz et al.
Good afternoon, Your Honors. My name's Philippe Zimmerman. I'm with Moses and Singer, and I represent the defendant appellant Moshe Dov Schweid on this matter. This is an appeal of a trial court's grant of summary judgment in lieu of complaint against Mr. Schweid on a personal guarantee. 3213 of the CPLR is explicit that a motion for summary judgment in lieu of complaint is only available in extremely limited circumstances. Those circumstances are where it's based upon an instrument for the payment of money only or a judgment. The guarantee at issue here goes well beyond an instrument for payment of money only. In addition, there's an issue with respect to Mr. Schweid's execution of the document, which I'll address later. As to the substance...
Is there a connection between the performance obligations here and the obligations under the guarantee?
Well, the guarantee on its face, and this is in record R162, looking at the guarantee, it states, the guarantor hereby absolutely, unconditionally, and irrevocably guarantees to lender the full and punctual payment of claims of every nature and description of lender against borrower, and any and every obligation and liability of borrower to lender of whatsoever
that says
nature.
And, counsel,
Excuse me?
that says and. Is that a condition precedent? Was the performance a condition precedent to the money being paid?
I believe it's an obligation to guarantee everything, every obligation of whatsoever nature, as this guarantee expressly provides. It's not limited to payment alone. It's payment and any other obligation. And in fact, when one looks at this guarantee provision, there's express reference to the loan agreement. And if one looks at the loan agreement under which every single obligation of the borrower is being guaranteed, those include numerous non-monetary obligations. It's every reference, it's every statement, it's every guarantee, it's every covenant. So to the extent any financial statements were provided, under this guarantee, the guarantor was ensuring the truthfulness and the accuracy of those guarantees. That is substantially more than a payment obligation being guaranteed. Beyond that, if one returns to the guarantee itself again,
I guess the question that I have for you again is whether, in fact, performance of any of those conditions were a condition precedent to the loan being given.
In fact, it is explicitly stated in the guarantee that the loan was conditioned on those promises, the commitment to guarantee all of the obligations of the borrower. Hence, it's not merely a condition precedent to the payment, it's a condition payment for the borrower having received these funds and every representation commitment made by that borrower.
But the plaintiff brought this lawsuit to recover money.
Yes.
This is an action for the payment on the guarantee only. The performance doesn't have anything to do with this lawsuit.
Your Honor, CPLR 3213 speaks of an instrument for the payment of money only. The Court of Appeals in Weissman made clear that the instrument has to be for the payment of money only. If it's a mix of obligations in addition to the payment of money, it's not an appropriate vehicle, 3213, for summary judgment in that context. They can bring their complaint, there can be discovery, we would have an opportunity to answer in that case, but it's not appropriate for summary judgment.
And yet our case law, though, seems to recognize that in this hybrid situation of guarantee of payment, guarantee of performance, as Justice Michael was asking you, and now Justice Kapnick, we look to see, was the guarantee of the payment tethered to some other obligation? Not whether there's other obligations in the guarantee, but the payment obligation.
The guarantee of payment, it's all within a single clause of the guarantee. It's all in Section 1 on 162 of the record. It's and, that's true. It's not conditioned.
But aren't they separate obligations? I guess, isn't that the question? Aren't they separate obligations? And again, what's the connection between payment versus performance? There's none. Both are required.
They are. It is true that non-payment is a sufficient basis, but under the authority of the Court of Appeals, it needs to be reviewed at the time the agreement is entered into as to whether or not this is an obligation for payment, an instrument for payment of money only. To the extent there is an issue with the restrictive nature of 3213, it's not an appropriate form here for this court to ignore the clear language of the statute, respectfully. The other issue I would mention very quickly is there is a matter of whether or not Mr. Schweid knowingly signed this agreement. The guarantee was signed after it was the signature pages of a bunch of documents were put in front of him by his fiduciaries with whom he had had a long-standing relationship. Mr. Schweid, a 72-year-old man, had these people come to their house, give him a bunch of papers, and he signed them. They had a long-standing relationship. It was clear from the beginning, and this is in the record in Mr. Schweid's affidavit, he had put up the hard money for the deal on the condition he would never be asked to provide a guarantee. And the other defendants in this case, who have not proceeded with their appeal, they agreed they would never ask for that guarantee from Mr. Schweid. And they unknowingly to him gave him a page, a signature page on a guarantee. Unless the panel has any other questions. Oh.
You'll get an opportunity to.
Thank you.
Thank you.
Your Honor.
Good afternoon, Your Honors. May it please the Court. Jose Fernandez for the plaintiff respondent, DB232 Siegel Mez, LLC. There is no dispute in this case about the existence of the guarantee, the underlying loan, or the fact that it remains unpaid, and the lower court's decision should be affirmed because this guarantee is an instrument for the payment of money only. The guarantee is absolute and
How do you address his claim that this guarantee does include an obligation to also guarantee performance and not just payment? So how does that make it an instrument for the payment of money only?
Sure, Your Honor. Well, first, we disagree that Section 1 of the guarantee includes a guarantee of the borrower's performance obligations. The operative language of that section is that the guarantors are guaranteeing, quote, the full and punctual payment of any claims, obligations, and liabilities of the borrower. So we fundamentally disagree with their interpretation of Section 1. But separately, this court has held that where a guarantee includes performance obligations, it is still susceptible to relief under CPLR 3213, where those performance obligations are not a conditioned precedent to payment. And here, the performance obligations were completely untethered from any payment obligations. This is an absolute and unconditional guarantee, and it was a promise to repay a debt that remains unpaid. There were no other conditions that were required for the guarantor's obligation to be triggered other than that the borrower did not pay the debt. So moving on to Mr. Schweid's fraud defense, Mr. Schweid's affidavit admits that he executed the guarantee, and I think it's important to look at page 175 of the record, which is the signature page. That signature page states, the guarantor has executed this guarantee as of the date and year set forth above,
and it expressly names the parties signing that document as guarantors in all capital bold letters. So Mr. Schweid's contention is not only that he did not read any of the other pages of the guarantee, but that he also did not read the page that he was actually signing that contains his signature, which he admits that he
So let's
executed.
assume he didn't do that. Can his negligence be used as a basis to say, in fact, or at least raise an issue of fact as to whether or not there was fraud in signing the guarantee?
No, Your Honor. We do not believe that his negligence could be excused. New York law is clear that a party is bound by the agreements that they execute. This wasn't a situation where Mr. Schweid was unable to understand the language of the agreement and was presented an agreement that he could not understand. This was a situation where he neglected to even inquire about what the agreement said. And there's absolutely no precedent that states that a party can rely on a fiduciary and execute blank signature pages and rely on whatever representations they make about it. And with that, Your Honors, if the court doesn't have any further questions, I will cede my time.
Thank you, counsel.
Thank you.
2 minutes.
Thank you, Your Honors. Very quickly, with respect to Mr. Schweid's signature, the general rule is certainly that a party is responsible for documents that they sign. However, under Sorensen, there's an explicit exception where they have been asked to do it in the context of a confidential relationship. Here it was a fiduciary, two fiduciaries, who came to Mr. Schweid to sign this. With respect to...
But they were his fiduciaries. It wasn't the other side.
That's true. That's correct.
Isn't this the rule usually designed to prevent one side from oppressive action of the other?
That is the normal circumstance in which it arises. But I believe it's also appropriate here where this is a joint and several guarantee. So effectively, Mr. Schweid, to the extent there's a judgment against him, is going to be providing a benefit to those who have harmed him here, who deceived him into signing this. With respect to paragraph 1 of the...
But wouldn't your claim then essentially be against the fiduciaries? What does the plaintiff have to do with that?
Although it's beyond the scope of the record, I'll note the plaintiff's focus is Mr. Schweid, not the other defendants. And that's because of their assets or lack thereof. Concerning the guarantee itself, while my colleague read to you an excerpt from it, it was quite selective in what he chose not to read as to the obligations. These are not merely financial obligations. If one goes on to the balance of that section, it speaks of not just payment, however, and of every obligation, but it says, including but not limited to those payments, obligations, and liabilities contained in the note, loan agreement, and other loan documents. Necessarily in referencing other obligations after payments, it's making clear it's not merely concerning payment. It concerns every obligation under the loan agreement.
Would you agree with counsel that under our case law, there has been an expansion of that doctrine, and you have to show a connection or condition precedent with respect to performance and payment?
I believe the I-payment case, which is one of the cases in which there's been somewhat of a more liberal understanding of how 3213 should be applied, treated them as if they were in separate provisions of the agreement, that it was not all in one single...
So why should it matter? Why should it matter?
Frankly, it shouldn't matter. The court, frankly, should be applying the rule as it's written by the statute, under the statute, and as it's been recognized by the Court of Appeals, which is an instrument for payment of money only. It's whatever we want to say here, this is not an instrument for payment of money only. In addition to the obligations I've identified, if one were to look at paragraph 10F, there are financial statements and compliance certificates that Mr. Schweid and the other guarantors were required to deliver on demand. Again, those are obligations well beyond simply payment of money.
Thank you, counsel.
Thank you very much, Your Honors.
And last but not least, People versus Herrera.
Good afternoon. May it please the court, Gwendolyn Parrish on behalf of Ramon Herrera with Office of the Appellate Defender. The beyond a reasonable doubt standard relies on the crucial and simple premise that the jury heard reliable evidence, not unproven allegations presented as facts. At the time of his arrest, Mr. Herrera was a 48-year-old man who used cocaine, who was living in an apartment, a tiny apartment, with other people that was stacked up with boxes and suitcases full of electronics and other materials, office supplies, nuts and bolts. Computer towers were everywhere. The alleged paraphernalia that was found in this crowded apartment was misrepresented by the jury, to the jury by the prosecution. First of all, the alleged diluent. The alleged diluent was based on insufficient evidence because the prosecution never presented evidence that it was, in fact, lactose, which it was alleged to be in the indictment.
Is that a requirement?
I'm sorry?
The proof that they have to prove the exact, the precise diluent?
Well, in this case, it wasn't just that they alleged it in the indictment. They also, during motions in limine, they told the judge that they were going to prove that it was lactose. Then the prosecution proceeded to open on the fact that this was lactose. They questioned it as lactose, and then they closed saying that this was lactose. Now, they needed to either produce a laboratory report or some kind of evidence that it was lactose.
Why? I don't understand. Why? Because they said it was part of their proof, that's why?
Well, yes, but also they never provided any evidence that it was in fact a diluent at all. There was no laboratory report done here, no laboratory tests.
Or wasn't there testimony by a witness with respect to the product?
Well, there was testimony that there are a number of substances that could be a diluent, but no testimony that this specific substance that they found that they never tested could actually fall under the statute. And so, they would have either had to produce some kind of evidence that this was a diluent, or they would have had to have some kind of testimony by an expert that said that this specific substance could be used as a given the circumstances of the case, as a diluent. And then moving on to the scales, if there are no other questions about the diluent, these scales were never proven to be functional. There was allegations that the scales could be made functional if only there were batteries installed in them that worked. But there is never actually any evidence presented that all they needed were batteries in order to work. And so, they found these scales in an apartment, again, that was stacked with things, electronics specifically. And among all of those things, there were 4 scales. None of them worked. The prosecution, the respondent...
Was there residue found on the scales?
What was that?
Was there cocaine residue found on the scales?
They never tested that either, actually, so we don't know what was on the scales. But the respondent has characterized this apartment as a drug factory, but in fact, this was, a middle-aged man living in a tiny apartment with other people. He admittedly used cocaine, and he had all of these things, and among those things were these scales that didn't work. And to characterize it as some kind of drug factory where, you could imagine somebody with like a shiny table out, packaging drugs and for
But
sale.
Isn't that, there were Ziploc bags, right?
There were also, there were used bags, which actually indicates use more so, I think, than it does indicate sale. There was also a bag of unused bags, yes.
And there was a metal strainer, right?
There was a strainer. We don't know.
With residue?
We don't know what was on the strainer. It was never tested. But again, we have a situation here where, drug use, I think at this point in time, we can all think of somebody probably that we know and imagine that, drug use is messy. This was a messy apartment. It was a messy apartment where there were a lot of things found with other people living in it. And, when we ultimately get to the criminal possession of a controlled substance charge, we have these other things, the strainer and the scales, and ultimately they lend themselves just as much to use as they do to a sale. here. And that's what we're actually asking this court to do, is to reduce the conviction from a criminal possession of a controlled substance in the 3rd degree, which is with intent to sell, down to the 7th degree, which is just a simple possession here. And, you know, because of the misrepresentation of evidence in this case, we're not really sure what the jury thought when they were convicting Mr. Herrera. And so, you know, with regard to the criminal possession of a controlled substance, we pretend that the evidence just as well supports use instead of sale. And I'll reserve the rest of my time for rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Assistant District Attorney Max Bernstein for the people. The evidence before the jury that Mr. Herrera, possessed cocaine with intent to sell it was overwhelming. He was found in his apartment with cocaine, 4 scales covered in white powdered residue, dozens of small baggies, some of which were used, some of which weren't, hundreds of dollars in cash, a sieve or a strainer, which also had white.
Was there a problem that none of these scales were operable and there was no testimony as to why or what they were going to do? There was really no testimony about that. Did the jury hear enough to be able to convict on that charge?
On the scale paraphernalia charge?
Yeah.
Well, the scale paraphernalia count, and nowhere in the case law is there any suggestion that the people are obligated to affirmatively prove that the scales were in functional order when they were recovered. The statutory language only requires that there be circumstances showing that there was intent to use the scales unlawfully, and we would argue that there were quite a few powerful circumstances that there were intent to use unlawfully in this case. All the surrounding circumstances of the recovery, what else was recovered?
There was no cocaine tested or cocaine residue tested on the scales, or was there cocaine residue on the scales?
The residue was not tested, as we explained in our.
It was residue, but it was never tested.
It was never tested, but I would contend, Your Honor, that whether it was dilutant or cocaine, whether it was non-controlled substance or cocaine, really actually doesn't change the upshot of the significance of the scales one way or the other. The point of the scales is to weigh out product after it's been cut for subsequent distribution. So whether what was actually on the scales was a little bit of the remaining cut or a little bit of the remaining cocaine really shouldn't alter the analysis one way or the other. The drugs were being packaged for sale, and what happened to have been left out on the scales, whether it was cocaine or not, doesn't really tell us very much about what the purposes of the scales were or whether or not the cocaine was possessed with intent to sell it. One way or the other, if there's residue on the scales and there's residue on the sieve, and it was white powdery residue, there was testimony to that effect, then we can know that the purpose of those things was to cut cocaine and then subsequently to sell it.
What about the defendant's claim as to the dilutant? What did you, I mean, you talked about it being lactose throughout, and then that's not what you proved.
So the references to lactose were repeatedly objected to on the record and stricken, so the jury was aware that we hadn't proved that it was lactose. There was no ambiguity in the record as to whether or not it was lactose because defense counsel was on top of it and objected to those references when there wasn't sufficient proof to it. But there was testimony in the record from both Detective Maldonado and Detective Welch that what was recovered was a cutting agent, was a dilutant. They were not allowed to offer their opinion that it was lactose because they lacked any laboratory report to do so, but they did testify that it was in fact a cutting agent. And
How
again,
did they know that?
well, again, you look at the surrounding circumstances, much in the same way the paraphernalia charge for scales requires that the surrounding circumstances show that there's an evincing intent to use as a cutting agent.
Well, what if it was cocaine?
Well, they did. So the small bottle, which had about 5 grams of white powder in it, was tested and was no controlled substance indicated, which is what the NYPD.
So it's the white powder presumably will be mixed with the cocaine. Isn't
Exactly. That would be the idea. So they knew it wasn't cocaine, not the residue. They didn't know about that. But for the largest pile of cutting agent, they did know it was not cocaine. And the surrounding circumstances.
Were they able to testify from their experience that it was a dilutant?
So the problem with testing to establish that it was a dilutant is that, and this is built into the language of the statute, is that almost anything could be a dilutant. And counsel in their brief mentions that this is sort of, it almost sounds in due process, the kind of broad vagueness of that anything could be a dilutant. But the cabining language is, again, the second part of the statute, which says evincing intent to use as a dilutant. And so you look at the facts on the ground. So one obvious fact here that it was being used as a dilutant was that it was also a white powder, like cocaine. So,
So you wouldn't cut cocaine with hot chocolate powder.
Something that clearly did not look like cocaine and would therefore tip off your clientele that they were getting something that was not pure product or something close to it. So that would be one fact. But I think the broader circumstances here show that we have more than just the fact that it was a white powder. It was recovered in a bag with 3 scales, immediately next to a sieve, in close proximity to cocaine, and the bag also contained a number of unused small baggies, which there was expert testimony to were used for the purposes of dealing drugs. So there was quite a powerful body of evidence.
Where was the cash found?
The cash found, I believe, was on Mr. Hura's person, and it was almost $500. So again, strong circumstantial evidence, and of course, it's a circumstantial statute showing that this was intended to be used as a diluent. And there wouldn't be any test precisely because the statute allows for anything, not limited to is the language in the statute, precisely because anything could be a diluent. There wouldn't be a test you could do to establish that this, if for example, this was citric acid, which there's a citation in the brief that talked from the United Nations Office on Drug Crime that talks about how citric acid is a commonly used diluent in cocaine trafficking. Citric acid is not included expressly in the statute. So if in fact it was citric acid, I think that would clearly fall within the language of the statute, which is capacious because that's a common, regularly used cocaine diluent. But if we tested it and found that it wasn't lactose or dextrose or one of the few things that's listed in the statute, I don't think that would thereby prove that we haven't met our burden. So there wouldn't really be a laboratory test you could do to establish that this was a diluent. You'd really need to look at the circumstances of its recovery, that it was a white powder, that it was recovered in close proximity to drugs, that there were scales and a sieve. And again,
but non-working scales, though.
Not working scale, or not operable at the moment. The evidence in the record is odd, concededly, but defense counsel repeatedly suggested on the record that the issue was a lack of batteries. And that's a pretty easily remediable issue if that is it. I think surely if lack of batteries is the only problem, you could absolutely still intend to use those scales for the purposes of weighing out drugs. And if I could just very quickly say, while there are some, admitted procedural difficulties or legal difficulties with the paraphernalia charges, I think very clearly the body of evidence strongly supports the conviction for the felony possession of it with intent to charge, however you slice the issues on the paraphernalia. And with that, thank you all very much.
Thank you.
Your Honors, the bottom line here is they could have done a laboratory test. They could have put batteries into these scales to figure out whether they worked, and they didn't do that.
But why does it matter if we look at the totality of the circumstances to make the decision? I mean, there's clearly it's a white diluent, or it's a white powder, white substance, and there's testimony that that's what's commonly used, et cetera, et cetera. There's Ziploc bags, there are twists, some are positive for cocaine. Based on all the circumstances, why isn't there sufficient evidence?
First of all, there actually wasn't testimony that this substance could be used as a diluent. There was testimony that there are several substances out there that can be used as a diluent by their expert. They did not actually testify to this substance under these circumstances.
Wasn't it a white powder?
It was a white powder.
Consistent with
I can't, I'm sorry.
Consistent with what cocaine looks like?
I can't imagine the legislature, though, giving permission for the police to go into a home where they find cocaine, go to a pantry, find a Ziploc bag of flour, and charge somebody with a misdemeanor. In this case, they didn't do what they needed to do to prove this evidence. The jury heard evidence that this was lactose, and the jury convicted based on that evidence. And it wasn't proven to be lactose, and there wasn't actually testimony that this was any other substance that could fall under this statute. Flour in a pantry couldn't fall under this statute. And to briefly address the operability of the scales, the bottom line there is that you can't use inoperable scales to weigh and sell cocaine. And he couldn't have intended to use those scales in the immediate moment to sell cocaine. And as far as the criminal possession of a controlled substance, we have a number of factors here that weigh just as heavily in favor of this being a drug use. There were used baggies, there were no working scales, it was low quality cocaine. And I realize that my time is up, but we do ask that you vacate the 2 paraphernalia convictions and reduce the criminal possession of a controlled substance conviction down to a simple possession.
Thank you, counsel.
Thank you.
Have a great evening.
Thank you.